Kind submission. There is an urgency in the matter. Tomorrow, the family court of Mysore has posted directed to pay the court fee, or else the suit will be dismissed. I have already sought for amendment. My claim is 12 lakhs, but however, the suit claim is made as
When is the order passed?
January.
And then why is
The
urgency now?
council was interested. He died, Mr. Dhananjaya. He died. File was untraced, my lord. So that only it is delayed. When Mr. Dhananjaya was the council, the file was handed over to him, my lord. That is the difficulty.
That cannot be the reason. And file it if the objections,
Take a chance
if
today.
if there are no objections, this is a matter on Monday.
Today end of the list. We will try.
No. We will not.
Monday.
With that kind of, Monday.
Monday.
Yes, next.
There is one urgency. I'm a party in person, RPSC 34 and RPSC 60 of 2018. So it was referred to Lok Adalat, but the respondent and her lawyer didn't appear. And there is an urgency because I received a notice for FLW. I have to appear for the lower court, even though I followed the stay order. But they are asking for more maintenance. So the disposal of is necessary. So kindly give date for
Tuesday.
so 25th of July.
It will come on Tuesday.
EMFC matter, I am for the husband. My husband is suffering from kidney disease, undergoing dialysis, and he had a recently heart attack, and NBW has been issued despite producing of the medical documents. He is not in a position to move also. That's why kindly have it on Friday or Monday.
Wednesday. Yes.
Here I thought wife has filed an application for interim maintenance, but the interim maintenance has been granted, 5,000 interim maintenance was granted to the site. Now, my lord, another application has been filed for education expenses. That education expenses has been dismissed on the ground that, my lord, already whatever the interim maintenance of 5,000 has been granted earlier is holds good for this education expenses also. The order has been passed last Saturday, my lord.
File it. Have you filed it?
I filed the application.
Objections or all objections are complied?
Yes.
If all objections are complied, fresh matters will come automatically. No, there is no requirement of a memo.
Tomorrow or Monday, my lord. Tomorrow or Monday, my lord.
No, if it is complied with, it will come. Immediately it will come. No memo is required. That's what standard instructions to the registry.
I filed it 4 days back.
Then find out if it is filed 4 days back. If the office objections are complied with, why it has
There was
not
only
come?
one office objection, my lord, and I have complied that also.
When was it complied?
Day before yesterday.
Find out why it is not coming. Yes.
My lord, fresh matter, my lord. Already office objection has been complied, my lord. The matter has not been listed, my lord.
Take all those memos separately.
My lord,
And 1 minute, find out from the registry why it is happening. Yes.
my lord, the court has instructed to serve a notice on another case, my lord. We have served the notice and the matter has to be listed, my lords. They have filed the wakalat also, my lords.
Yes. I'm coming in line. Yes.
Regarding the DD that has to be handed over to the respondent, your lordship was well aware. Twice I have moved the matter. They have lost the memo and DD is expiring on 22nd, if I'm not mistaken. Not sure why. They said to wait. They will find the memo, post it before the court. Twice moved the memo.
I didn't understand what it is.
This is regarding the handing over of the DD deposited by the petitioner to the respondent. Twice I have moved the memo for posting.
Then that was modified. It was not modified.
It wasn't modified. That's what they are saying.
It was modified.
Plus they're saying it is not modified and it has to be handed over to the respondent is what we.
Wednesday. Yes.
Plus another memo also I had moved on the same date because the mediation failed and it's a fresh matter that has to come up for preliminary hearing.
Saturday, Friday. Yes. You are for the respondent. Which year is the petition? I said which year is the petition or the RPFC? 2024 has become old in 2025. Please wait. Yes. There are so many matters. How do you expect the court? No, that list when that all the matters were directed to be listed, all orders matters of 300 or 400. Tomorrow, don't give any other members. Yes.
Plus, I have filed application under 151 for recall of order minutes. It was disposed of. The first time it has been listed on 3/6/2025 minutes. And then on 10/7/2025, it was disposed of as an officer business not compliant with. I have filed recall application. I only two
To
objections.
file it, let it come. When you are not, when you are not diligent in doing, and when the court dismisses it,
I had to file for translation.
we'll see, it will come on its own. No, if for everything there is no, when you're supposed to do something, you don't do it, court dismisses it. Again, for that a memo, little you file it, even whenever the court finds time, it will look into it. No memo, yes. Call,
Memo 8/23/6 was directed to be posted on 25/6, my lord, as per my lord's instruction. On 25th, my case is not posted. I represent respondent wife and I have filed application to evict the stay order. She's in dire need of money. She's suffering with several medical aids.
take that
90.
Tuesday, next Tuesday. Yes.
Page-wise
And
adjournment.
as far as adjournments are concerned, without any reason, if you make a request, then court has no other option but to reject it. So please make mentions if there is urgency. There is any need.
23 minutes. Regular 23 in orders, I may be permitted to withdraw the.
Call the list.
Page-wise adjournment. Page number 11.
Yes.
Page number 11, hearing on interlocutory applications, 38 to 40. Page number 12.
Yes. Yes.
Serial number page number 12, serial number 41 to 48.
My lord, serial number 41. Serial number 41. I am the petitioner actually. 41, I am the petitioner, needs to be clubbed with 72, my lord, but I have a personal inconvenience today. Lords may have it on 5th if I may request.
It will be too late. This is the third
First
time
of
they are
August.
taking time. Your
First of
lordship,
all, there's a medical emergency, that being the reason, my lords.
I do understand, but twice already.
I've
they are
informed my
taking
learned
time.
friend yesterday over a
Third-
text
I'm
message.
not saying it's not in.
No, why not we have it on 28th?
My lords, I would not be there in the last week, that being the
28
reason, my
would
lords.
be-
1st of August is also fine, my lords.
This is a matter on 1st of August.
41 and 72 may be clubbed, my lords.
41 post along with 72 on the day.
My lords, 44.
Yes,
42 only.
take that. The memo is filed stating that the dispute between the parties is amicably settled.
Serial number 44, I've
So
informed my
wants
learned
to
uh,
friend. my
withdraw the
lords.
writ petition, dismissed as withdrawn.
Number 43.
Ah,
Happened by interim order to maintenance in the MC. MC order disposed there.
when was it disposed?
And that what order has been passed? 1 week 90 time.
In your whatever order, if MC is disposed, nothing remains to be there in this. Huh? Tomorrow.
I will produce the order.
Tomorrow, order not required. You can tell what is the number, file a memo. Why should it be pending? Yes, Monday.
Serial number
43 on Monday.
44, my lords.
Huh.
My lords may have it on 5th, my lords.
Have you informed the other side?
Yeah, my other side.
Yes, at the request of the council, the respondent.
44,
This is this matter on
5th of August. Grateful, man. So obliged.
Yes.
Page number 13, serial number 49 to 50, 60. Page number 14, 61 to 67. Page number 15, 69 to 75.
Lord, serial number 7.
Order number 74, could your lordship have it after 2 weeks, my lord? 74, my lord, I mean,
Exploring the opportunity of settling, my lords.
Why when the matter is listed of 2021, if this is pending before this court from 2021, where is the question of exploring now?
Lords, I filed
you
another
want to
execution.
explore, if you want to explore.
My lord, my clients are willing to withdraw the visitation rights. Therefore, I spoke to the counsel for the petitioner.
They approached me quite recently, my
I'm not
lords.
more than that. We will not keep matters pending before this
Please,
court.
my lord, please.
Let,
1 week, 1
if
week,
any
my lord.
scope is there, because the main matter itself is pending before the court, you can explore there.
1 week, my lord, please.
1 week, my lords, I will report the
It is
settlement as well.
submitted that the compromise talks are going on, list this matter next week, after a week, give the date, and no further time will be granted.
Please,
Great,
my
my
lords.
Yes.
31-7.
Great, my lord.
So page number 16, serial number 76 to 85.
Serial number 76, my lord.
Hmm.
It's a pro bono case. Senior counsel will argue this matter, my lord. Kindly push it on 23. He will be physically available.
This is matter on 23rd.
3. Yes.
This is matter on 23rd. Yes.
Serial number 85.
Huh? 23rd. 25th. 25th. Hmm.
For 85 million. I'm for petitioner. Time at a week's time.
Have you informed the
Already
respondent?
informed.
Then the request will then counsel the petitioner list this matter next week. It is submitted that already it is informed to the counsel for the respondent. Yes.
Page number 17, serial number 86 to 92.
Serial number 86, my lord. I am from petitioner, my lord. 2 weeks time, my lord.
Why time?
Madam,
By time.
senior personal inconvenience, my lord. Senior.
Then if you're not interested now, we'll give you a long date. This is matter on 1st of September.
Yeah, was-
Anybody ask time, they'll be, they are getting a long date. So please think and then ask. Yes.
Serial number 23, madam.
23.
Permitted to withdraw.
Yes. Is that? Hmm.
23, in order.
It is, a memo is filed that the petitioner is not interested to prosecute the matter. And say that the same may be dismissed as not pressed. Accordingly, the petition is dismissed as not pressed. 17. Take that. It is, a memo is filed stating that already the main MC, that's MC number 1422 of 2018, is settled in the mediation by order dated 21/12/2023. Hence, nothing remains for consideration in this said petition. Accordingly, memo is taken on record and dismissed as withdrawn. Yes. Hmm. Huh?
Mike use my decision.
Why you want date?
Liberty, assessment liberty is filed. Assessment liberty is filed, madam, to be filed.
You represent whom?
Petitioner, madam.
What about respondent?
Respondent is informed.
Judge Lazarus,
Informed.
This matter also, 84, lives the matter on 20th of August. Yes,
Serial number 12, my lord.
Hmm.
I may be permitted to withdraw. my lord.
yes.
Serial number 22, my lord.
1 minute.
12.
The petition is where a memo is filed seeking to withdraw the petition. Memo is taken on record. Dismissed as withdrawn.
Serial number 22, my lord. I am for petitioner. I'll just verify in low court. It is disposed, it seems, my lord. I'll just verify. So I seek for-
22 lists the matter on tomorrow. You get it?
Yes, ma'am.
Tomorrow lists the matter tomorrow. Hmm. Yes.
My lord's kind of one pending now for posting in one pending matter. Madam, the respondent has obtained maintenance in 2 cases. One is under section 125. Another is in maintenance is a divorce petition. Interim order has been obtained. Let she get the maintenance in one petition, my lord. For consideration of the interim prior, I have filed a memo. In this regard, it may kindly be taken at any convenient day, my lord.
Take that. Someday, look at the memos, someday in the next week. Yes.
My lord, may I request, my lord, one request. Serial number 10, I'm not well, my lord. My senior is also not well. Kindly take it up on Monday, my lord, please.
Non-compliance of office objections, what is to be taken? 2019 matter.
Please, my lord, Monday, my lord. I am on 10.1, my
Office
lord.
objections shall be complied with within a week. Default order.
Much obliged.
Yes. Call the list.
List number 1. Ordered matter, serial number 1, SG Bhagwan. for petitioner. Gururaj.
Your Lordship.
For respondent.
And for the respondent, Your Lordship. My learned friend had suggested for some settlement, Your Lordship, but however, it's been referred to mediation
When it
twice.
has come before the court, 2011 matter.
Please, Your Lordship, it
What
had
settlement
been,
now?
it had been referred to mediation. However, my client was not present. I was present, my client was not present. I've always been advising her to come. However, if 1 week may be given, I'll talk to her as a final chance. If not, I'll argue on my merits, Your Lordship. I've also spoken to my.
Many times the accommodation needs to be done.
Please, I agree.
2011 petition cannot be kept pending. I have to pass orders and I'm passing orders. Please argue on the merits of it. Court is not at all interested for your clients leisurely coming whenever she feels like. Argue on the merits of it. Yes. Where is the impugned order?
Sir, petition. Annexure A is the.
You are the, who is the petitioner? Yes, please argue.
Impugned orders.
Yes, where is it? Page number?
Pages 14 and 15.
Yes.
And 18 and 19.
Yes.
2011, 20, 26 to 21. 14 and 15.
Yes, let's read the order.
End of page 15. Order. Petitioner is hereby directed to pay or deposit entire areas of interim maintenance as ordered in MC number so and so. Then page 18, type page. In view of non-compliance of said order and default, the petition, it ought to be petition, petitioner is not entitled to further prosecute this petition. So dismissed. In the writ petition, and it is undisputed, I have stated, I am looking after the wife. Respondent.
What is the age of the petitioner and the respondent?
Now the age of the petitioner would be 62. Her age would be 52. I am looking after the children. I have sent my daughter to London for higher studies. Undisputed. My son is also under my custody. Often he goes to the mother, comes back. And the mother is staying in the house which belongs to me. A part of the house, she has rented it out. He may be getting about 20,000 rupees. These are the facts which are undisputed. I have stated it in my repetition itself. Apart from that, I have stated it in my application also. Therefore, my lord, there is no ground for the wife not to cooperate and to go to the mediation center.
No, we are not talking about what has happened between 2010 and 2025.
Yes.
We are on the point, what was happening in 2010 when this order was in 2010 when this order is passed. We are looking at the legality of the order as on that day. What husband is doing from 2010 to now is not the concern of the court. As on that day, what are the grounds that are stated in the writ petition? Please come to the grounds.
Page, your lordship may turn to 8, page 8.
Yes. Nothing.
Page 15, serial number 15, at page 7. The petitioner states that the orders dated 2010-20 and 26/2/2011 in Annexure A, passed by the court below in miscellaneous number so and so, are arbitrary, opposed to the principles of natural justice, unreasonable, bad in law, disliable to be quashed. Then, my lord, at page 17. petition
No,
number
no,
so and
no.
so.
We will not go to 17 at all. We have to look at the order is passed stating that on so it is dismissed for non-prosecution. You have not complied with the order of the court.
Yes.
Now how the court should come to your rescue. Then you question that order in 2011. You raise the grounds. What are the grounds? The court below exceeded its jurisdiction in putting the petitioner on terms. He has no remedy alternative to approach the court.
I have made an application to condone the delay.
How much is the delay?
Delay about 70 days.
So, first of all, now we will not go into the facts. What was the husband doing? We will only, you can restrict your arguments to the order impugned, and when that order is passed, why is it bad?
Husband is an architect, practicing architect. Now the order is at page 14.
Yes, I've seen that order, complete order I have read. So what is wrong with the order? Please point out.
Petitioner is hereby directed to pay or deposit entire areas of interim maintenance as ordered in MC number so and so. That would come to 2,70,000 rupees. I paid that amount to her.
If you have paid, then the order will automatically, then you are entitled for restoration as on that day itself. Then where is the question of the matter pending before the court? That's what precisely the trial court said. You pay the amount on that condition, the order will be restored. Where is that? Then why should you come to this court if you have paid?
With regard to that aspect, if the court does not take into consideration that aspect of the matter and passes the order.
Which aspect of the matter was not considered?
That I have paid.
Where is that? Where is the evidence?
Detaining her.
No, where is the evidence before the court? Without you telling the court, how will the court know?
So, para 17.
Of what?
Of the petition. I have stated.
Let's see.
The petitioner has been ready to have the matter settled amicably, which the respondent had no objection initially. Even now, he is ready to do it. He is maintaining, educating, and looking after the interests of the children. He will continue to do so. He also submits that as per the request of the respondent, he is supplying grocery and other household items to her as and when she requests. He also submits that the respondent is staying in the residential premises owned by him. So I have been taking care of her. There is the question of continuing the order. That is why it was sent to mediation. Unfortunately, she does not cooperate before the mediator.
Yes.
If the mediator talks to her and says, "Look here, what is all this? What do you say?" Then we'll learn the matter post.
Come. Agreed with the orders passed in miscellaneous number 36 of 2010, dated 2011-10. The husband is before this court. Court has an application is filed under order 924 to set aside the dismissal order dated 24/11/2009, passed in MC number 646 of 2005, and to restore the said petition. In the said MC, the court has passed an order granting interim maintenance to the wife. The court has observed that the interim maintenance comes to an amount of rupees, the two arrears of maintenance comes to an amount of rupees 2,70,000. And as the petitioner, as the husband had failed to deposit the arrears of maintenance, but he is coming before the court and seeking restoration of the MC.
The miscellaneous. Of the miscellaneous.
After the MC petition was filed, it was dismissed for non-prosecution.
I understand that. He has filed the miscellaneous petition seeking restoration of the MC. The court has dismissed this as the petitioner at one hand cannot disobey the orders of the court, and on the other hand, he cannot seek a relief from the court to set aside the dismissal order. Agreed thereby, the husband has come before this court. This writ petition of the year 2011, this matter is from that day is adjourned on several occasions, and finally the matter was sent to mediation. And the same was written as a respondent has not settled, as a respondent has not appeared. Today the land counsel appearing for the respondent submits that again, if some more time is granted, they would work out they'll try to compromise this matter. The matter which cannot be compromised from the last from the last almost 15 years. The 450 on that ground, this court is not inclined to adjourn the matter. Learned counsel appearing for the petitioner submits that petitioner husband submits that the husband is taking care of all the expenses of the wife, of the children, and he has been taking care of the education of the children. The wife is residing in the house where which belongs to the husband. When he is taking care of all the requirements of the wife, the court ought not to have passed such an order imposing the condition that unless and until the arrears are cleared, the order, the MC will not be restored. Land counsel appearing for the respondent, you dispute or do not dispute that is pending amount?
I do dispute.
Huh?
I do dispute.
Land counsel for the respondent submits that.
I agree that she's staying in the house, but
Land counsel submits that the house in which the respondent wife is staying belongs to the husband. But however, with regard to the educational and other expenses, as stated by the husband, the wife is disputing the same. Have you filed your objection?
She is not disputing.
I have not.
No objections are filed by the respondent. This court has perused the order passed by the court. This order, as on the day the order was passed, the arrears of maintenance was an amount of rupees 2,70,000. The court has every jurisdiction to pass an order imposing conditions when on one hand the husband seeks restoration of the suit as a restoration of the petition, MC petition, and on the other hand he has not complied with the order of the court. Court has directed the husband to pay the arrears. On such ground the MC would be restored. The submissions that are made by the learned counsel appearing for the petitioner with regard to taking care of the education and other expenses, this court cannot look into those things which were happening from 2010, from the date of impugned order till now. The court can only look at what was the right, or the order passed by the court was right or not, as on the day that was passed. This court has also looked at the grounds, except saying that the order of the court is arbitrary, illegal, and against principle of natural justice. No other grounds are raised. Hence, in the considered opinion of this court, the no interference is required with the well-considered order passed by the court. Accordingly dismissed.
Please.
Obliged.
Who's wakalat? Your wakalat is not there.
In the name of Guru Raj R.
Huh?
In the name of Guru Raj R.
But the wakalat not filed even on his name also.
I'll verify the same. I'll
Yes.
Number 2,
Respondent counsel. What is your name?
Aishwarya Hegde.
So and so representing so and so submits that they'll file the wakalat. Yes.
Lord,
Cell number 2.
the
Isma
subsequent
Rajaraja.
development, my lord. There is one case is the present MC before Udupi court. And in Hubli court, my lord, restitution for conjugal right is obtained by the husband.
So what is impure order?
Now,
First, let's see
now
that.
this is the proposal is my lord. This now the daughter's proposal is my lord getting engaged. So, but for that my lord, this dispute is coming in the way. Now the daughter is persuading the couple to my lord to resolve the issues because she is a MBBS doctor. She for her marriage proposal she wants to resolve this litigation. So the undergoing process with through the elders is going on. My lord. The short accommodation I will not take further adjournment. You may have it on 4th. And my lord, on that day, if nothing is sorted out, well, I'll go on with the matter. Because taking the interest of the that daughter wants to resolve the issue, my lord. It's only ego is going on between the parties. Husband has obtained a decree for restitution of conjugal rights. So, you may have it on 4th, my lord. I'll proceed with the matter. That's why I informed the
Where
other
is
side
it
also.
for the respondent?
Please, my lord, Mr. Ajit Shet, I informed him, my lord, in the morning
It
session.
is submitted, there is a likelihood of settlement. This is matter on 4th, whether the matter is settled or not, the court will be passing orders on the not settled.
Grateful.
Cell number 3. Ruling Murthy. Here. Nagaraj S.
Take that. A memo is filed stating that the petitioner is not interested to prosecute the matter. There is a stay in this. No, an order is stayed subject to the condition that the entire arrears of maintenance shall be paid. And you have been enjoying the interim order right from 2022. What happened to the respondents? Who appears for the respondent?
Nagaraja S.
Arrears of maintenance is paid? Huh? Use the mic.
I have no information about the maintenance, madam. I will make our submission, madam. Kindly pass over.
Tomorrow, pass over. Get instructions on this.
Yes, madam. I will take instruction.
Pass over. Cell number 4.
Respondent.
I'm for the petition in this case, ma'am. Lord, in terms of the order dated, my lord, 5/2/25, my lord, I need to deposit, my lord, entire arrears of rent at the rate of 10,000, my lord. As per the order of this court, my lord, I have deposited sum of rupees, my lord, on 23/4/2025, 2 lakhs, my lord. And subsequent to that, my lord, I filed the present IA, my lord. And after that, my lord,
Paul, have you served the copy of this extension petition on the counsel for the respondent?
my lord, I have already complied, my lord. Entire amount I have deposited in terms of the order.
No, that you're not pressing on the tie.
Because, my lord, after expiry of the order, my lord, I have deposited. So that learned trial judge.
How much you have deposited?
My lord, on 26/6, my lord, 2,58,000 I have deposited. Earlier to that, my lord, 2 lakhs I have deposited.
2 lakh?
2 lakh. As on today, my lord, 7,30,000 I have deposited. Entire amount which
7 lakh?
30,000.
Withdraw.
50,000 arrears as per the orders of this honorable court they're supposed to pay, my lord. That apart, this year's school fee, books, uniform and all.
Where is the order?
My lord, it was a submission made by them orally that they have been paying the school fee and other things on their oral submission.
Let us,
It was not
we
ordered.
will hear it on the merits of it. You know, at this point of time, we have to restrict to the interim order.
Please.
As per the interim order, the entire amount is paid or
No,
not?
my lord. Another
According to
50,000
you,
they're
what is the
supposed to pay.
calculation?
Another 50,000 they're supposed to pay.
Tell it what is the amount, what is
Received.
what is the entire amount that has to be paid?
My lord, they're supposed to pay altogether 7,80,000. They have paid 7,30,000. Other 50,000 is arrears as per the orders of this court.
7 lakh?
My lord, the total is 7,80,000, my lord. Out of that, 7,30,000 have been paid. Another 50,000 they are supposed to pay, my lord.
Yes.
No, my lord. As on, my lord, 5/2/2019.
I'll pass over this matter. Please look at that calculation,
Please.
both of you, and submit. Yes, next.
Cell number 5. Kumar K. For petitioner, Latif B.
Interim maintenance was under challenge.
What are these many petitions? 5 is filed by whom?
First
in-
petition
Five
filed
is
by,
filed by the wife seeking enhancement.
please.
Then
Then now it is posted for orders in stage of evidence has completed, and they never turn up for arguing this petition. Therefore, it is posted for dismissal and connected matters.
no.
Please,
5 is wife's petition for enhancement.
please.
What is 5.1?
5.1, you are also one application is filed under section 21, production of the document to show our ailment and other things. And second
That's filed by the
application,
husband.
second application
No,
to
no, no,
recall
wife.
PW1.
Wife.
Second petition is your also to recall PW1 to marking those documents which has been filed in the earlier application. Third application is in the third petition, your also pertaining to an application is been filed, furnishing the sources of income of the husband.
Let's take. First argued 7305. Where is the impugned order in 7305?
7305.
Please. At page number 23.
No, who is the petition in 5?
First petition, Lord, the wife filed, the council, the same party, they are appearing in IA file for production of the documents. The parties are wife only, they filed all the petitions.
Then why, who is appearing for the wife in this?
One of the cases, another council is appearing, he is not turned up.
He is
The
not
same
appearing.
party is.
We'll hear it and pass out.
Please.
So the council is not there in 5.
Not there.
The matter is directed to be listed as there was no representation on behalf of the wife. This on 17/9/2024, this court had directed the matter on 17/9/2024 also. There was no representation on behalf of the petitioner. And the matter was directed to be listed under the caption for dismissal. And even when the matter is listed today under the caption for dismissal, today also there is no representation. Accordingly, the petition is dismissed for non-prosecution. Take the next case.
Please.
Take the next case.
Yes, sir.
Yes, next
First
case.
petition, your lordship filed an application.
Where is the impugned order?
Your lordship in page number 17.
17.
Yes, sir.
Yes. Please read the order.
Yes, sir. Before that one, you are also in page number 18, you are also turn it.
Yes.
18.
Please come to reasoning part, para 6.
Yes, sir. There are two applications filed by the petitioner, one in application under 91 CRPC, stating that production of the document in the application, no iota has been made of. Your lordship, see the application, your lordship. It is in page number.
We'll complete this and go there.
Yes, in page number. Yes, document. Iota of reference of the nature of the document, relevancy of the document, and there is no reference to any document. Merely an application has been filed with sale as section 91, but factually there is no mention of any nature documents in the application. Merely citing the provision under section 91 CRPC by itself, it does not show the nature or relevancy of the document. Under section 91 of CRPC, production of the documents is necessary, is desirable for the purpose of the trial or other proceeding. Such document has to be produced. In order to enable the court to find out if the document is necessary or desirable for the purpose of the above case, there is no mention of the document at all. Application.
Yes, where is that application?
Yes, I produce.
Page number?
Application your recipe is there. To petition. Application your recipe is internal page. Internal
57.
page 57, your Lordship. 57.
Yes, please read that
Yes, sir.
petitioner filed the above case against the respondent. At the time of filing has no relevant documents.
Affidavit, your Lordship.
No, those documents, that's what I'm looking at, the typed copy of your annexure D.
Yes, your.
That at the time of filing petition has no relevant documents. No, those documents are available to file before this court. Wherefore, pray that to condone the delay and permit the petition. What is wrong with the order?
My submission, your Lordship. Along with the application, your Lordship,
What is the purpose of filing an application
in page
before
number
the court?
59, your Lordship turned it.
No, no, please tell the court, what is the purpose of filing an application?
That's what you are asking. 59, in page number 59.
Yes,
That is C, para number 2. That is CD has been produced which recorded on 8/1/2022 in the respondent clinic. One is Udayagiri and another is Woodco Bannimanta. The two videos of the respondent were practicing and suppressing this quote. That the details of the videos was taken through mobile Samsung notice so and so. Udayagiri clinic. And another one is Vivo mobile number so and so and on 2018 at the Metro matrimonial home where respondent was staying.
yes, what do you say? They have stated the reasons at page number 59.
That is the separate
One
one
is-
more application that was challenged in another writ petition.
So this is not, this is a separate,
That's separate. Then one more application. 65B.
One more application, I will come to that point. First, I will submit this one. The
So please
second
tell the
application,
court-
one nimsham. One more
you have to
application.
wait for a minute. I am asking you a question.
Press.
58 and 59, are they one and the same?
No.
They're different.
They are
So
different.
as far as this impugned order is concerned, where is the application?
My submission, your Lordship, is in 59, it has been stated what is the application your Lordship.
Saying,
Yes,
you are saying that 59 is nothing to do with this impugned order.
It is along with the application, your Lordship. Along with the application. I was informed that it has been filed along with the application. 65B.
No, next petition is another IA.
And
For another IA, 59 is the application.
This application, your Lordship, so far in the application is no details of the document want to be
Please
want to
come.
produce, not produce.
Please
But
come.
only thing is has been clarified in the next application, yours on
It
the
is
same.
impugned in the other case. That we will
Other
see.
pertains of some other case.
So let us see, give the next
Yes,
case.
yes, your Lordship. Your Lordship, see that application. Your Lordship said, last month. That application is
Where is the application?
1559, your Lordship. 1515, your Lordship. 5115, your Lordship.
1550.
Yes, your Lordship.
43, 41 ಅಲ್ಲ?
What is the number?
Internal page is 63, your Lordship. First of all, I would say, so the application, your Lordship. 63, your Lordship. 63.
5.3.
Where is the application in this?
Application in 63, your Lordship. Annexure D, your Lordship. List of the document produced. Last salary slip drawn by the respondent before the retirement. List of the retired benefits, PF, gratuity and total amount received at the time of retirement. Details of the pension, monthly pension. This is different, is pertaining to the respondent because he is a practicing advocate, a doctor. He's
What about the next petition, see?
next petition you are recall by the
Point two.
recall because by filed the application with the earlier petition 91.
Yes, Mr. Counsel, why you are saying that they are one and the same? They are not one and the same.
Lord, both application filed under section 91. One application, there is no narration about what the documents are they are producing.
Please look at the first one. 58, 59 is connected with that.
Please.
In 59, they have given the details why it is. Now, when it comes to this, the other petition, it is a separate application, separate details. You cannot say that application pertains to this.
Ultimately, Lord, the purpose is they have to produce, they will produce some documents about my salary and account details. I have filed an affidavit and as per the guidelines of the appeals court, as per Rajnish and the Neha case. Lord, it is my duty, Lord, I have to place it in the affidavit of my salary. When the fag end up,
What did you
matter
say?
of the year 2018.
What did you say in your statement of assets and liabilities?
But that was submitted with, that was the observation made by the trial court. Already he filed an affidavit in support of.
Wherein, what have you stated? What is your avocation? What is your income?
Lord, I was a practicing a doctor, and I was serving in the government department when I was arrested by the police by filing on criminal case. I was being suspended. Then, Lord, I was retired from the service, and documents, those narrations were made in there. I have not disputed my avocation. That was the observation made by the trial court. When the matter of year 2018, the applications were filed of in the year 2022, after 4 years, when the matter is posted for orders. That was the observation made by the trial court.
Please come.
If you ask to see that application itself, 311 application, it is in page number, second application petition, annexure D in page number 57.
Yes.
Further submitted that now above case has been assigned for judgment. Further that at the time of petitioner's evidence, the petitioner under mistaken impression that she has already produced the important document which is now she has going to produce, and subsequently she came to know that no such document is produced. As such, the present documents are very much documents are produced. As such, the present documents are very much necessary to adjudicate the matter. The delay is bona fide and not deliberate one. Hence, the application to recall PW1 for the purpose of producing the document and further examination. So that application, your lordship has narrated what is the document she wanted to file it in the application. Though in 91 application, it is specifically not mentioned what is the document she wants to produce. It is, I don't like to what happened when the application is filed. I am not aware about that because it is my transfer. The second aspect you are asked, I narrated in the application what is the document I am going to produce. So that these are the documents to show goal. One is there is no dispute regarding the respondent and the petitioner husband and wife. The respondent suppressed the fact that he is a practicing doctor, suppressed it. Subsequently, he has retired, got provident fund, gratuity, services, etc. Those documents have not been produced before the court. Then I wanted to produce those documents to show that he is a solvent person, able to maintain me, but he has suppressing those facts, avoiding to pay maintenance. Even your last till date, he has not paid earlier maintenance paid, ordered with honorable court at rupees 3,000 per month. Till date, he has not paid. That is the tactics of the respondent. He wanted to see she has to come to her terms and condition, one way or the other way. But what I want to submit, she is a Pradhan lady. She relying upon the trial court advocate what he is going to do. And of course, I am not blaming anybody. But only the thing is, in the application, she has been clarified what is the document. So that those documents as produced, no hardship will going to cause to the respondent. Then, if recall it, you are asked to fix a date. Within so much of period, you lead your evidence, close your side, post for argument. So far,
how you are retired from service?
Third application.
Why you are not paying the 3,000 which is ordered by the court?
That I don't have any such. They have filed execution. I don't know whether they themselves obtained interim order here, one there.
They obtained what interim order?
There is a proceedings were stayed by filing the petitions by them.
Yes, in the three petitions, proceedings has been stayed. Proceedings stayed means the interim application order passed by the honorable court not stayed. Further proceedings in the trial court has been stayed, not the payment of the maintenance.
Kindly see the observation made by the trial court, para 40.
Since 6 years, he has not been paid. That order has not been stayed. He is also not challenged that order. It reached finality at that stage.
Then why have you not filed an appropriate application before the court to strike off?
I submit you. I submit. Why you are asking? It is a Pardhanasi. She relied upon the advocate and given document. For the reason best known to the trial court advocate.
Why have you not filed execution till now? From the last 6 years, if he is not paying the money.
He has not come certain times, and court time has to do, and she has led evidence, and it is posted for respondent.
She is
evidence. At
residing
that time,
my house.
Respondent
One more
evidence.
thing is, my mother's house they are staying. My mother had approached the Senior Citizens Act, under the Senior Citizens Act, to occupy that premises. In spite of that, there is an order from the Assistant Commissioner Court to vacate the premises. But in the domestic violence, they sought a accommodation in my house. They are staying. And daughter is now is completed BE and she is working in a company, private company. Those are all the facts are there. Not those materials were not placed here because there was a parallel proceeding.
Not the material.
Please.
When the order of the court has passed an order, why are you not complying with it? And why should we hear your case?
Lord, when the matter is posted for final orders, these applications are filed.
What about that amount? Ask your client if that amount is not paid. When an order is passed 6 years back, if you are not complying with the said order, I will allow all these red petitions. Tell him. We'll have it tomorrow. This is matters tomorrow as parted. If he has no respect to the orders of the court, no, we will show him how it is. We'll allow all these red petitions. Yes.
Much obliged.
And delete from the caption dismissal and court has parted. By that time, the respondent counsel shall get instructions why the husband is not paying the maintenance of an amount of 3,000 that is granted by the court from the last 6 years. Whether he has questioned the said order. Yes.
Number 6. Srinivas DC.
My lords, I'll take necessary steps, my lords. I have to.
24.
Yes, I had taken steps previously. I have not
On
furnished the
behalf of no
acknowledgement.
representation, furnishing of so-and-so for second time, details so-and-so. When was it? Week's time, default order.
Much obliged.
And the petition is permitted to take out a hand summons on the counsel appearing for the respondent before the trial court. Same shall file a memo by 29th of July or else the petition stands dismissed.
Much obliged.
Cell number 7. For orders matter, cell number 7. Pushpa Veni, IG.
What is that for complaints of order dated 1812? What is that order? No representation for dismissal tomorrow. Yes, 8.
Cell number 8. Cell number 8.
For dismissal tomorrow.
Cell number 9.
My lord, appearing for petitions, my lord.
Shriram HC.
Settlement agogide, my lord. We're seeking a date, my lord.
First of all, if you want this petition to be alive, you should comply with the office objection.
My lord, a date time will be given, my lord.
A week's time default order.
Cell number 10.
Much obliged, my lord.
Number 11. For the petitioners in case 11.
My lord,
Venkatesh R. Bhagat.
I am for the petitioner. The main matter itself is disposed of, my lord. I have filing a memo. It become infructuous, my lord.
When it is disposed of?
2021, my lord.
Memo is filed stating that the MC 12 of 2016 is disposed of on 22/2021 and nothing survives for consultation in this petition. Accordingly, memo is taken and dismissed as withdrawn. Next 13.
Cell number 13.
Non-compliance of office objections raised on statement filed by the advocate. Copy is not served. Have you served the copy?
We have served them, madam.
It is submitted with the counsel for the respondent that they have served the copy on the counsel for the petitioner. Then
And also vacating of stay, we had filed.
you have served?
Yes, please.
It is submitted that the respondent has served both the copies on the counsel for the petitioner. No representation for the petitioner. List this matter for dismissal on Wednesday.
Please.
Yes, next.
Cell number 14.
Madam, appear for the petitioner. Notice has been served, my lord.
Yes.
I have taken the notice, my lord. I got the postal acknowledgement stating that she has been served.
What it says is rectification of office objection raised, not acknowledgement for having served application filed by advocate for that is only RPAD received is affixed.
RPD sent by post, my lord. And they have received it also. I got the postal information from the post, my lord. I've taken the acknowledgement from the postal department.
The office
I
objections.
filed that memo, my lord.
Office objections to be complied with within a week, default order.
Bill
Next
number
15.
15, we are Balraj.
For dismissal tomorrow, no representation.
Serial number 16, PV Kalpana.
The main MC matter has been disposed of on 10/11/22 minor.
It is submitted that the main MC itself is disposed of on 10 by the counsel of the petitioner on 10/11/2022. And nothing serves for consideration. This petition dismissed as infractious. Yes, next.
Serial number 17, disposed. Serial number 18.
Returned with
18.
answer absent. No representation for dismissal tomorrow. This
Serial number 19.
Yes, memo for withdrawal.
Yes.
Look at it. The memo is well stating that the disputes are settled between the parties. Memo is taken on record and dismissed as withdrawn. Next 20.
Serial number 20. Satish B.
In this matter, respondent has filed an application for vacating interim order and as well as an objection. They have to comply it, my lord.
The respondent shall comply the office objections within a week or else the IA stand dismissed without further reference to the court.
Serial number
Yes,
21.
Much
Abhinay
obliged.
Vaiti. 21.
For dismissal tomorrow.
Serial
No
number
representation.
22. 22 urgent, 23 disposed, 24. Serial number 24.
View that.
Guru Prasad.
On 26/3/2025, an order is passed whereby 10 days time is granted to make payment of necessary process fee in respect of the unserved respondent. If the same is not paid by 4/4/25, released on 9/4/2025 for dismissal. Today there is no representation on behalf of the petitioner and process is also not paid. This is a matter tomorrow for dismissal.
Serial number 25. Syed Akbar Pasha.
No representation tomorrow for dismissal.
Sincere apologies.
Serial number?
Serial number 21 is rendered infractious, my lords.
21.
21 is rendered infractious. They've settled the matter before the courts below.
The 21.
21, my lords.
Okay, dismissed as with nothing survives for consideration. Dismissed as infractious.
Okay.
Yes, next.
Serial number 26. 26.
No
Gangadhar.
representation for dismissal tomorrow.
Serial number 27. Serial number 27.
Petitioners, my lord, the petition stand infractious, my lord, since the parties have settled the matter through compromise.
Same. Yes, next.
Dismissed as infractious. Serial number 28.
For dismissal tomorrow.
Serial number 29. Muralidhar HM.
Notice to the respondents returned with an endorsement unclaimed amounts to deemed service of notice. List this matter for hearing. Print the name of the respondent. List this matter on 5th of August.
Serial number 30. Memo for retirement.
My lord,
Do that. What is that?
the respondent in CMS 408 of 19 filed an IA seeking for interim maintenance, my lord.
Memo is filed for retirement.
Yes, my lord. But in the last date of hearing, the opposite counsel stated that they would withdraw the petition, my lord.
No representation. This is matter for dismissal tomorrow. Next 31.
Serial number 31.
I have to take steps regarding the
Take court notice on the counsel appearing for the respondent before the trial court and file a memo by 28th. If the memo is not filed, the writ petition stands dismissed.
20th.
Serial number 32.
This is a matter.
where the maintenance has been interim maintenance has,
Notice is served.
please, Your Lordship.
What is this? Why
What
this?
else there are left?
What about R2? He appears for only R1.
R2, it can be dispensed with, Your Lordship. That's the child. So the same can be dispensed.
Memo.
Give a memo.
We will file it.
Write
Lordship.
it and give.
Please,
A
Your
memo
Lordship.
is filed stating that the R2 is the minor represented by the petitioner and notice to respondent may be dispensed with. Accordingly, notice is dispensed with.
One request, Your Lordship. What has happened in this present situation is
So if it will not be heard at this stage, if you want, I can hear it some other day.
a short adjournment may be given,
And
Your Lordship.
list it on Tuesday.
Please, Your Lordship.
Cell number
Write the memo and give right now.
33. Cell number 33.
I'm appearing on behalf of the petitioner, Your Lordship. Your Lordship, there are certain office objections raised.
Everything has to be cleared unless and until all these office objections are complied with, I'll not hear the matter.
Your Lordship, just one request, Your Lordship. We would want to explore the opportunity of settlement, Your Lordship. If my learned counsel would agree to this.
Where is the party in person?
She's unwell.
Humble submission, my lord. I was not feeling well, my lord. I have already submitted along with IA my disease conditions. So I had a very serious leg pain, my lord. So I couldn't come.
Why IA?
Your Lordship, I've just come on record on the last date, Your Lordship.
No, when she is represented by the advocate, why the IA that she is not feeling well? How is the court concerned?
I wasn't aware of the IA that she has filed, Your Lordship. She has filed multiple.
She is burdening the registry with all these IAs.
Exactly, Your Lordship. I absolutely agree.
What is happening is she is not able to get the relief. She is not understanding. At least you do some, it's a big help you will be doing.
Your Lordship, I have advised her saying that we'll explore the opportunity of settlement. She's agreed for the same.
Have you agreed, or then you will say that even my advocate has cheated me?
No, my lord. No, my lord. I have sent everything as a WhatsApp message also, my lord.
Whenever you're representing, please assure that she is around you. Otherwise, she'll make allegations against you also.
Yes, Your Lordship. I asked her to come today, but she said she was unwell and she'll
Is there
appear.
online?
Yeah.
Then counsel for the petitioner submits that they want to explore the possibility of mediation. For this matter.
Can I make a humble submission?
What?
I wanted to apologize, my lord, because of the misleading advice only I have filed that contempt petition, and within 1 month, in the first day itself, I have withdrawn it.
From now onwards, number one, don't appear in as party in person. Believe on some advocate and go as per their advice. Then you will get the relief.
Okay, my lord, and one more humble submission is that one judgment order is already been passed, my lord. On basis of that, one execution petition also I have filed, which is also pending in the third additional same family court Bengaluru. So instead of another mediation to execute the matter,
Mediation,
When?
Your Lordship, this Saturday.
That's on 19th.
19th, Your Lordship.
Party shall appear before the mediation center at 3 p.m. on Saturday. No?
As per your convenience.
Monday at 3 p.m. Monday happens to be 21st. Yes.
I'm sorry, mother.
Huh?
I'm sorry, mother.
my lord, I have a humble submission because when there is already a mediation happened and then there is a judgment order, my lord.
Yes.
Till number
Next.
34.
I appear for the petitioner in this matter, my lords. I've taken the process, my lords. I have filed it on 9th April 2025.
Not taking of hand summons, why you're not?
Please, my lords, I'll do the needful. I have given process. I'll do the needful.
When
also.
is that order passed? When an order is passed, that is something to be.
No, process has been taken by me. I've taken the steps regarding process.
Not taking of hand summons. I asked you to take hand summons. Why did you not take?
No. On 9th April, I have taken that.
The petition is permitted to take out hand summons, not on the respondent, on the counsel.
Please,
When
my lords,
counsel for the
I'll do
petition is
that.
permitted to take out hand summons on the counsel appearing for the respondent shall file a memo to that effect by 28th, or else the petition shall stand dismissed.
A date may be fixed for admission.
That's what I said, 28th.
Oh, blessed.
Sorry, mother. Serial number 18, mother. I'm sorry, mother. 18 is in practice, mother. Ado tomorrow date agide.
You should have come when the matter is
Sorry,
called.
Mother, I'm waiting here, Mother, suddenly it was.
18.
18, writ petition 6847 of 2021, Mother.
What happened?
That before the family court, Mother, petition was disposed upon.
MC or criminal miscellaneous?
Please, Mother. MC, Mother.
Submitted that the MC itself is disposed of.
On 30th September 2024, Mother.
30th September 2024.
24,
This
Mother.
has become infractious.
Please, Mother. Sorry, Mother, I'm sorry.
Is dismissed as infractions. Yes, next.
Cell number 35. Purnima, 35.
Not taking of hand summons. Yes.
Awaiting.
You appear?
Not after petition on 35, my lord. Serial number 35.
Non taking of hand summons. Why?
My lord, we have served, my lord, we have served it to the trial court advocate. It was
That's what I
permitted
have.
to us.
But as per the cost title, it says you have not taken hand summons. Look at it. Give it to her.
My lord, I'll check with that, my lord. I'm not aware of it.
Yeah. This
But the interim
tomorrow.
order is complied, my lord. We were granted
This
2
is matter tomorrow. No, we are more concerned on the notices. No, right. There are matters where right from 2020 notices are not served.
I understand.
Now the
I'll
notices, notice drive is going on. Yes, sir, is next part. Then in 35, petition is permitted to take out hand summons on the council, same like in the earlier order. The date is 28. Memo, if it is not filed, the same would be dismissed. Yes.
Grateful, my lord. I'll do the
Counsel.
needful. Grateful.
Yes.
Cell number 36. 36.
For the
Mahesh
respondent in this
DJ.
matter.
You appear?
Appearing
Yes,
for
ma'am.
petitioner.
Today, I filed a wakalat for the respondent.
So and so submits that. He has instructions to file wakalat.
My lord, interim order to be extended.
Instructions to file wakalat. The counsel for the petition shall serve the copy of the writ petition on the council. Interim order earlier granted is extended. This is matter on 11th of August. Next.
Cell number 37. Ravi Shankar. TP.
Madam Lord, last occasion, Lordship interacted with children.
Children, sir, last time they were present.
Yes.
For,
You are the arguing counsel.
I am for petitioner. Sir.
Yes. Last time I asked you to find out from the children from the other advocate was appearing on the other day.
Yes,
Where
he is my colleague. He is on the way, my lord.
Ask him. Pass over.
Please, please.
Why the writ petition has not complied with the office objections? Office objections. We'll do one thing. Comply with the office objections. List the matter.
Overall, that is overruled, my lord.
Then why it is show that?
Regarding the non-filing of typed copy, my lord, the office objection was raised.
Is it overruled?
It is overruled.
First today, my lord, your Lordship held that it's not
Then why
pressing
are
with
they
that page.
showing it?
And the last occasion also, the children also present before the court.
That I remember.
Please,
That I
please,
remember.
please.
He had submitted that he will not press that
The
particular page.
objection that the legal eligible copy of page number 41 to be furnished. Matter may be posted before the matter is posted. In spite of repeated, why this court has overruled? It has not. It has asked you to do it.
Please.
The office objection shall be complied with. This is matter day after tomorrow. If the office objections are complied with. Yes.
Please.
Cell number 38. Latif.
Hearing for petitioner, my lord.
Yes.
IA number 1 for delay may be allowed, my lord.
Have you filed your objection?
I filed
My
an
lord.
objection.
Keshkini.
A serious objection, my lord. 568 days delay.
Yes, where is that? First of all, we'll look at their IA, condonation of delay. Where is that?
Even in a single
page
para, they have not
A
mentioned
number?
the reason for delay. my lord.
IA number 1, my lord. Page number 78, my lord. The affidavit is in page number 79, my lord.
79.
76, I think, in my
79.
that is a stay application which he is referring to.
Filed by whom? Wife or husband?
Sorry, 76.
Filed by
my
husband.
lord.
Petition by husband. Page number 76 may kindly be seen. my lord. That is the affidavit which they filed. not even a single para to say why there was such big delay of 568 days.
In execution page, he has paid 2,41,000, my lordship, after.
What are these reasons? Can on these reasons the court can condone the delay?
Your lordship, they obtain a
If
divorce.
you want to argue, argue, or else if any your senior wants to come, let him come. I'm not going to condone the delay. Let your senior come.
Kindly pass over, my lord.
Pass over.
Cell number 39.
230.
Yes, notice.
Yes.
230.
Cell number 30. The 40.
What is this modification of the order dated 19/3/24?
The respondent wife.
The amount has been already paid, my lord. In this,
May I?
Who filed the petition for modification?
Petitioner.
19/3.
The submission, my lord. Originally, my lord.
Let me look at the order, then I'll understand what is it.
Yes.
my lord, in order to modify the amount
Let me
from
look at the order. What is this 19/3 order? IA number is filed for amendment of the writ petition, paragraph number 7A. Then counsel the respondent submit that he has no objections to allow the IA.
Yes.
Accordingly, IA is allowed. What is this now? This order is 19/3/24. You are seeking a modification.
Yes, my lord. It's already been filed long back and it's been submitted already. The modified, it's already modified.
Where is it?
May I?
Modified has been submitted on
What is the date of that order, modification order?
modification order date is
23/9.
23?
yes.
9.
This court to direct the particular amount of.
23/9.
It is unconnected.
No, my lord, what happened, my lord? Originally, your lordship had directed him to deposit 25 lakhs by a certain
Let
date.
us not go into that.
Yes, yes.
Please look at the cause list.
No, no.
Cause list
I was
says,
only trying to provide.
IA
it.
number 1/24 for modification of the order dated 19/3/24. What is this 19/3/24 order? IA number 1/23 is filed for amendment of the writ petition in paragraph number 7A, 7B, 7C.
Yes.
Then counsel the respondent, he has no objection to allow the IA.
Yes, accordingly we are modified the.
I think there is something you're not understanding what the court is saying. 19/3/2024 order, you want it to be modified by IA number 1/24. What is to be modified in this order, I'm asking?
My lord, it was submitted by the earlier council and then the modification in the
IA number 1/24, at least let me, I think it is difficult to understand now. Where is IA number 24?
Your lordship may kindly see the order dated 19/3, my lord. Subsequent to that IA1 being allowed, there is a detailed order passed as well.
my lord, in IA, we requested that it is married.
Please look at your prayer in the IA.
Yes. They reduced the amount from 25 lakh to 15 lakh rupees.
Here the difficulty is about what has been mentioned in the prayer.
Yes.
Prayer, you are seeking 19/3 order.
Yes.
I think you're not understanding in spite of me telling you again and again.
My lord,
Saying the prayer, look at the prayer, that is wrong prayer. You have to correct it. You are not seeking clarification of that order. You are seeking the clarification of some other order. Read the order, Mr. Counsel. Read your
my
own
lord.
petition.
Yes, my lord, this is what is happened in earlier council.
So you have to at least change it.
Yes, yeah, I'll
Do
change it. This is the first time I'm appearing before you.
The petitioner, the IA number 1/24 is filed seeking a modification of the order dated 19/3/2024 when they are seeking a modification of an order that is passed by this court on which is the date?
The date is
Which is the date, madam?
19/3, my lord, there is a detailed order subsequent to your lordship, sir. kindly see the next
Okay,
page.
the
of-
order is 19/3/2024.
Please come.
19/3/2024.
After that IA1 of amendment was allowed, my lord, subsequently there's another order.
19/3/2024.
Hmm.
The
The
detailed order.
IA1 has been filed by us, and it has been allowed since the council has told that they don't have any objection. Followed which there is the, may I read that fully? The 20th, the husband is before this court questioning the maintenance of the 50,000 granted by the court below the respondent wife. Now, after filing the writ petition, amended application is filed wherein amending the paragraph, it is stated that during the pendency of the proceedings, the before the court below, respondent wife has agreed to settlement and husband was ready to pay 42 lakh, and after agreeing for the same, again the wife had gone back and
So why this order to be modified?
my lord, she has gone back from the same day after the preparation of the mediation report. She was not agreed for the 42 lakh rupees. There was some discrepancy in the small amount of jewelries. She went back, and then all this the procedure has been stopped, and they came back with the 50,000 has to be paid with the new order of 25 lakh rupees. This honorable court has passed for the 25,000 rupees to pay the amount for them, and it has been honored. That's it. We are paying now every month 25,000 rupees as per this honorable court's order.
Yes.
That's what is happening now. That's all, my lord.
Yes.
My lord, after the order that was passed on 19/3, directing him to pay 25 was not paid, so this application was filed seeking for modification of that 25 lakhs. My lord. Subsequent to that, your lordship had passed an order on 23/9.
23/9,
2024. So your lordship said that since this application was
No,
heard.
in the earlier order, this court had directed the petitioner to deposit an amount 25 lakhs and he has deposited 17 lakhs.
Yes.
17 lakhs
Was
deposited.
deposited. As of now, this order is being complied with as well. Your lordship may continue reading.
My lord, as for this 23/9/2024 order, it said that he has deposited an amount of 17 lakh. Both the parties submitted that they have not filed the statement of asset and liability before the trial court, and it was during the COVID time 2019. Considering the same, the husband shall pay maintenance of the 25,000 per month from the date of the petition till now. He shall calculate 25,000 per month and deduct the said amount from the 17 lakh rupees which has been already paid. If any other amount have to be paid, he shall pay the same within 15 days. Again, that has been considered and paid 19,25,000 rupees it comes, and that has been already paid. And there is no, as of now, any due in this particular case. My lord, this petition is only to reduce the 50,000 rupees to 25,000. So we are ready to pay that 25,000 rupees. My lord, presently I am not in a job.
The writ petition doesn't say reduce it from 50 to 25 at all. It asks to quash the entire order. Lordship may kindly see the relief sought in the writ petition. This honorable court for the interim period had directed this.
So.
Very well.
No.
Now,
as per this,
insofar as that
one
IA
minute,
is
as per this, order is concerned.
Yes.
The court had directed the husband to pay 25,000.
Yes.
He has deposited 17 lakhs before the
Yes.
17 lakhs.
Subsequently paid
So
off.
what the court said, you calculate from that day.
Yes, yes. That has
and
been
accordingly-
complied with. There is no difficulty.
Then why should now, already that order is clarified in this order?
That insofar as that IA for modification, my lord, I'm not on that. I'm on the merits of the writ petition itself. I'm not.
What was the order passed by the family court?
Annexure A,
What was granted?
50,000.
Hmm.
Subsequent to this, my lord, there was a subsequent order passed by this honorable court asking me to file a memo of detailed expenses of the child. Because the child in this case, my lord, suffers from a bleeding disorder called hemophilia.
I remember that case.
Yes. So with subsequent, I have then on the
And
last
that time,
occasion
Mr. Arun
filed a
Govindraj
memo.
was saying that the all hospitals, there is a facility.
Government hospitals grant free. That also I have clarified in a memo, my lord, which I have filed. I've sought instructions as to whether that particular factor medicine is available free of cost in the hospital or not.
What is the income of the husband?
5 lakhs a month is what he has
My lord,
deposed.
right now, he's not in a job.
He is
He's no
deposed.
more in a job and he's at home. He has been, due to some issues, he has been asked to resign and he's no more in the
When
job.
he resigned?
Just 3 months back.
No,
I
my
can
lord.
produce the document of that.
My lord, I'll produce the
I'll produce the
deposition of the conducted before the lower court, my lord, where he's admitted till June 3rd. He's been in a job and his last drawn salary was 5 lakh rupees per month. I can produce that certified copy of that deposition before this court.
For me, the information is from my client. He has put down his paper. As they asked him to put down the paper, he has
Regardless.
put down his paper. He's no more in the job. That's what my information. And that's what he
Regardless,
promised me
Get that, we will
Regardless,
decide.
I will
We'll decide this
produce-
matter. Heard the councils.
Cell number 40.
And my lord, sir, they are given the memo.
IA number 1 of 24 is concerned
Calculation. Supporting
with regard to the
documents.
modification of the order dated 19/3/2024 in the light of the order dated 23
9/9/2024.
23/9
2020.
2024, no clarification or modification is required. And accordingly, IA is dismissed. List is matter on 4th of August by the time, list is matter on 4th of August. The land council for the petitioner submits that, petitioner father submits that. Now he is out of job from the last 3 months. Land council for the respondent submits that he was doing job till June and his salary as on the day was 5 lakhs. And she will place the documents before this court. Both the parties are at liberty to file the documents with regard to the.
My lord, one has submitted a memo and there is no supporting document for that. It's just calculation of some kind of figures and all submitted. The direct them to submit all the supporting document for this.
So what is that?
It is for the college, the school fees and the medical expenses and all this.
Do
There is
it.
no supporting document at all.
Do it.
Cell
Yes,
number
next.
41 to 44 adjourned. Cell number 45. Ajay Jain Andalike. 45. Arun Govindraj respondent.
Yes.
Both parties are almost on the verge of closure. It should happen within a week or so. May I request the matter be adjourned to 30th? It's acceptable.
It is submitted that as per the order passed by this court, the parties have approached the process of mediation, and there is a likelihood of settlement. This is matter on 30th. Interim order earlier granted is extended till. You file your. He submits that yes.
Because they're already represented in the US. So both parties, the Lords may both parties may be directed to get an adjournment.
Both the parties shall not precipitate the matter.
No. Apply to US court for adjournment.
That's what they're not precipitating is they're not insisting.
My lord, I'm sorry, my lord, I'm not submitting myself to jurisdiction of the US court at all. I've only filed my response saying court has no jurisdiction. I don't need to file for adjournment.
I don't want them to object. I will apply for an adjournment. On my accord. I don't want them to object to that. That's
No, if they object, you can tell the court. They don't do it. For that, an order needs not be passed.
record that I will be taking adjournment.
It is submitted that before the US court, when the matter is coming, they'll take the petitioner husband will seek for an adjournment. This is matter on 30th. And what about these objections? IA number 1 of 25. Take that. What is that IA number 1 of 25?
Annexure B legible copy.
Let's see.
Dispensation.
What is that annexure B?
It's very clear.
sir. I number 125 is filed, seeking to dispensation of the production of the better or legible copy of an It is submitted that the plain that is filed before the court is legible. Hence, this sought for dispensation. Accordingly, I 125 is allowed, and production of the better or legible copy of an is dispensed. Yes. Next.
Cell number 46.
No representation for dismissal. Yes, tomorrow.
Cell number 47. MM Ashoka Syed Khalil Pasha.
No representation for dismissal tomorrow.
Cell number 48. M Muni Krishna.
Same order.
Cell number 48. 49.
Same order.
Cell
49
number,
you appear? Yes.
Sarvana S. 49.
No notice from 2022. No notice from 2022 in repetition. Notice is not ordered. Why? No urgency for you? List along with so and so on 24th. Huh?
478.
That's what. List along with so and so. Yes.
Cell number 50. Mohan BK.
Yes, for dismissal tomorrow.
Cell number 51.
Appearing for petitioner, my lord, in this case.
Yes.
The video is muted, my lord. I'm appearing for the petitioner, my lord. But in this case, my lord, the petitioner, my lord, the respondent, my lord, she herself has filed a affidavit to the department, to the military department, stating that she is not willing to join the petitioner. She wanted the pension amount from the petitioner, this thing, my lord.
6,000 maintenance is granted.
20, my lord, is receiving only 17,000, my lord. Out of that, my lord, 27,000 out of that, my lord, most of the
You please come to the court. I'm not able to hear you. Please this matter tomorrow.
Cell number 52. Vajravadi Siddeshwar.
Yes. 2021. Which court is this? The present petition is filed seeking disposal of MC number 2. Huh? What is that? MC number 2063 of 2021 on the file of the Second Additional Family Court, Bangalore. The present petition is the counsel for the petitioner submits that there shall be a direction to the family court to dispose of the matter in a time-bound manner. The family court is burdened with matters. The MCs which are much before, even from 2016 are pending before the courts. And this court cannot give any direction to the family court to dispose of a matter out of turn. And this court has specifically directed the family courts to dispose of the matters till 2019 on priority basis. In that view of the matter, no orders can be passed. Dismissed.
Cell number 53. Adish Balu.
What is the impugned order? IA number 208 filed by the petitioner are hereby partly. Who is the petitioner? Husband? Father? Take out notice to them. Take out notice to the council. Same hand summons. List is, if the hand summons are filed, whenever the hand summons are filed, list the matter. The memo for yes.
Cell number 54.
Yes.
Monisha,
Come, what is impugned? Where is the impugned order? Page number. 1 minute. Let me look at, because it's your case, you understand. In a manner like I understand, you have to proceed. Where is the impugned order? No, you cannot. You cannot. You have an option. Why are you coming to the High Court? Is it a summon is an impugned order which is amenable to 227? Go before the court. Tell the court that it has no jurisdiction. Whatever it is, the High Court, when you can come to the High Court, you can go to the family court also. Please come. The present petition is filed seeking the following prayer. It is a case of the petitioner that the marriage was performed on 14/2/2017, and in view of the differences between the parties, both the petitioner and the respondents are deciding separately from June 2023. On 7/8/2023, the respondent has filed a petition in MC number 355 of 2023 on the file of the First Additional Principal Judge Family Court, Bangalore, under Section 27(1)(d), read with 30 of the Special Marriage Act. Then on 7/11/2023, petitioner has filed a petition, that is GNWC number 392 of 2023 on the file of the First Additional Principal Judge Family Court, Bangalore, under Section 7, 17 and 25 of the Guardians and Wards Act for custody of the child. And he has also filed MC with the court of the First Additional Principal Judge Family Court, seeking judicial separation. On 12/7/2024, the petitioner and respondent signed the mediation agreement in MC number 3993 of 2024 before the court of the First Additional Principal Judge Family Court, Bangalore. On 29/8/2024, decree was drawn by the family court in MC number 3993 of 2024. Thereafter, the petitioner has filed a complaint against the respondent as he is not able to know the whereabouts of the minor son and for not complying the conditions of the mediation agreement. And the petitioner filed a complaint before the District Child Welfare Committee against the respondent. The wife had filed GNWC 21. The respondent had filed GNWC 217 of 2025 on the file of the First Additional Judge Family Court, and a notice is issued to the respondent and a notice is issued to the petitioner. Then counsel for the petitioner submits that when already the disputes between the parties are settled and the earlier proceedings have attained the finality. Now the husband cannot, now the respondent cannot file a JNWC, and issuing the summons in the said case itself is bad. Hence, the petition is before this court, questioning the said summons issued. When the summons are issued to the petitioner by the court, the petitioner could have submitted all these facts to the very same court which has issued the summons. The respondent might not have disclosed the facts, and a notice is issued. Once these facts are brought to the notice of the court would be passing an appropriate order. For that purpose, the petitioner cannot approach this court. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to appear before the court and submit his case.
Cell number 55, Sachin BS.
Yes.
petitioner is challenging annexure A, where my impleading application in the 125 proceedings came to be dismissed.
Please come to that order.
Please, my lords. In page number, my lords, annexure A, my lords.
Annexure
A, page number 10, my lords. 10, my lords. Reasons are there at page number 13 and 14, my lords.
Who filed, wife filed?
Please, my lord. Wife filed in a 125 proceedings, my lords.
And
then she
implead petition
remarried.
is filed by whom?
Please, my lords. I had filed an impleading application to, she had remarried during the pendency of the proceedings, my lords. So I filed an impleading application to implead the second husband, my lords.
Why is it necessary?
Because that was kept abeyance from the court only. She has not stated before the court. Please,
If you say that she is married, you can produce any other evidence. Why should he be impleaded? Why is he a necessary party?
My lords, that was not come to the notice of the court at all, my lords. Thereafter, when I filed an application for impleading application, then she comes and states that, my lord, she will take the maintenance only till the date of her second marriage, not beyond that, my lords. My lords, the proceedings were from 2014, my lords. In the year 2024, my lord, she filed an. She married in the year 2020.
I understand all that.
Please,
you can say there is suppression, misrepresentation.
Please,
why should a second husband be impleaded? She is not denying the fact. And what is the purpose of impleading him? And what is the benefit you get?
Just on the sake of equity matters, because she has kept in abeyance before.
Please come. Agreed with orders passed in criminal miscellaneous in I number 1 and criminal miscellaneous number 616 of 2024. I think we should dismiss it with cause. 616 of 2024 dated 16 January 2025, whereby the petition herein whereby the application filed by the petitioner herein under order 1 rule had filed an application to implead the second husband of the respondent wife was dismissed. The respondent herein has filed a criminal miscellaneous number 616 of 2014 seeking maintenance. Now the present application came to be filed stating that the wife had contracted a second marriage and the said person is a proper and necessary party to this petition. The wife had filed her objections stating that she remarried on 1/9/2022 and she is entitled for maintenance till the date she got till 1/9/2022. Then by order impugned, the court had dismissed the application, observing that there is no proper reason to allow the application, how the proposed respondent is necessary party to the proceedings. And the wife has also undertaken that she will not claim any maintenance from the husband after the date of her remarriage, that is 1/9/2022. Hence, the court has come to the conclusion that the respondent is not the proposed party is not a proper and necessary party to the proceedings and dismiss the application. Learned counsel appearing for the petitioner submits that though she has married in the year 2022, the said fact was suppressed. Hence, his presence is very much necessary to decide the dispute between the parties. Next para. Having heard the counsel for the petitioner peruse entire material on record, the application, in a 125 proceedings, when the wife herself admits that she has married and from the date of second marriage, she will not seek, she is not entitled for maintenance. This court is not able to understand what is the purpose of impleading the proposed party. The court had rightly considered and passed a reasoned order, and there are no reasons to interfere. Dismissed. Yes, next.
Chair number 56.
Lords, I am for the petitioner in this case, my lords.
Yes.
Lords, being aggrieved by the order dated 19/1/2024, my lords, I am before this honorable court, my lords.
It is that order.
My lords, at annexure A, page number 12, my lords. My lords, I directly take my lords to page number 12, my lords. Sorry, my lords, 13, ink page number 24, my lords.
IA number 5 filed by the respondent on section 4 of the Hindu Marriage Act is dismissed.
24 is dismissed, my lords.
Notice.
Lords, my lords, one submission, my lords. he has not disclosed his assets and liabilities in detail. Lords, number second, my lords, he has also not filed his.
What order you expect now from the court?
Lords, at least interim order, my lords, at least for 20,000 rupees, my lords, because, lords, today, my lords, as of now, my lords, I am staying with my parents.
Petition is permitted to take out hand summons on the counsel appearing with the respondent before the trial court and file a memo to that effect. Once the memo is filed, list the matter.
Cell number 57.
Great.
Mahesh
Yes,
Chandra
57.
BN.
Yes.
Petition challenging the interim maintenance.
How much?
This 10,000 has been granted, and the petitioner hearing is a agriculturist who is having a marginal holding of 1 acre. And my lords, your lordship may kindly see the discrepancies in the petition.
Come to the impugned order.
Kindly, my lords.
Page number.
At page number 54, my lords, reasons at page number 63 and 64, my lords.
Please read.
Para 17, my lords.
Please read.
The respondent has admitted the fact that he is having land properties in his name bearing survey number so and so, measuring 4 guntas, and survey number 40/1 measuring 1 acre, and a house property measuring so and so, totally measuring 110 square meters. The lands are situated at Mullur village, Jaipura Hobli, and all these properties are inherited by this respondent. The respondent has got produced documents before this court to prove that the mother has taken treatment at Sigma Hospital and has underwent surgery, and for this he has spent huge amount. The respondent except stating that he has taken jewelry loan, Indian Overseas Bank, to which he is paying monthly installments and also paying monthly interest of so and so, with the separate loans borrowed by him, has not clearly stated his actual income. The respondent has also not shown how much he is getting income to repay the loans every month. The respondent has not produced any documents before the court to prove his exact income. He being an agriculturist, my lords, he will be growing vegetables and other things. He cannot be producing documents to show.
Please come, learn counsel. The petition submits that the court has granted an amount of ₹10,000 per month to the respondent. As interim maintenance, he is an agriculturist and is not in a position to pay the said amount. Same 50% arrears at 5,000, arrears at 5,000 within 8 weeks. List the matter on 11th August. By the time the learned counsel, the petitioner shall take out hand summons on the counsel for the respondent and shall file a memo to that effect. If the memo is not filed, stay granted by this court stands vacated.
Great.
Number 58.
And even for that also default order, 5,000 by 5th of every succeeding month and the arrears. Yes.
Same order, my lord. The petitioner is
What is that same order?
poor agriculturist, my lord. The 10,000 has been.
Come to the impugned order.
Please, my lord. Annexure H, my lord. Page number 50, my lord. In the absence of assets and liabilities, my lord, this order.
Why did you not file? You should have filed.
They have filed application, my lord, for interim maintenance. They have filed application.
You have to file your statement of assets and liabilities. Without filing the statement of assets and liabilities before the court, you cannot tell this court with regard to the relationship.
My lord, she left the matrimonial home in the year 2019, my lord. The petitioner filed a restitution in the year 2019. Thereafter also, she did not join the petitioner. Now he is filed a divorce against a respondent in this, my lord. And also the respondent is a MEA graduate. Respondent is a
order. This order, 51 order, 50 order. Take a printout and send to the chamber. No, and send it to the registrar R&S and registrar judicial both. And then inform it. 50. Please come. Same order like in that. In this, it's 20,000 per month.
10,000 has been ordered, my lord.
10,000, same order in that.
Well, 10,000 ordered.
5,000.
3,000, my lord. He is a poor agriculturist, my lord.
Yes, once he comes. Why have you not filed your statement of assets and liabilities? First of all, no interim order should have been granted. Yes.
Please, madam.
Admission matter. Cell number 59.
Serial number 59 appear for the petitioner, my lord.
In this
Yes.
case, I filed an IA, my lord, restraining the respondent for seeking benefit from the insurance policy which I paid the insurance premium, my lord. My lord, actually, we both are working.
Where is the impugned order?
My lord, I filed an IA, input, sorry, my lord.
All that we'll not consider here. We are only, now we are on this petition is, where is the impugned order? We'll consider whether the impugned order is correct or not.
Impugned order, my lord, at
Yes.
page number 30, my lord, in my petition, RPRC.
What is that?
That is
One
page
minute,
number
1
30.
minute. Yes. Correct. Yes, Mr. Counsel, last occasion, what is the amount you have got from the insurance and what is the amount you have paid? I wanted you to get those instructions. Where are they? Yes, Mr. Counsel. Where is the order on that day? Land counsel for the petitioner submits that the petitions are placed 10% of the bills before placed 10% of the bills before the insurance company where they can be reimbursed. Whatever payments that are received from the insurance company shall be placed before this court, and basing on that, further orders will be passed.
My lord, insurance, both are working, my lord. Both have got the group insurance policy. And from my insurance policy, my lord, myself covered and my parents and my child and husband. And same thing, he has got the insurance policy.
On the last occasion, what you have said is 90% of the amount you have paid, only 10% you got the insurance. In that case, court has asked you, how much amount you have received from the insurance and what is the amount you have paid. That is very simple.
That's I placed it before in my IA itself. I placed it before your lordship, my lord. Your lordship may kindly see. Here itself, I placed whatever the insurance that is at my IA along with the documents.
Have you filed any application?
Along with the documents at page number, 1 minute, my lord.
I'm asking you, last occasion the matter is adjourned. After that, have you filed any document before the court?
Yes, now document has been furnished before your lordship.
When is the order passed for this court? After 4/7, have you filed any document?
Yes, today along with the IA, I have filed documents.
This is the one.
Document on 15/7/2025. Copy also furnished to him along with the IA.
Yes.
IA 1 of 25, sir.
Yes, IA 1 of 25. On 15/7/2025.
Yes.
Only day before yesterday, I filed before this court and copy also furnished to him. After furnishing copy to him, only filed.
Yes.
Along with the documents.
Please tell what it is. I'm looking at the document.
Yes, my lord. At page number 20 and 21, my lord. 2021 at the end, total medical expenses 8,83,000 for the cancer treatment. Total claimed expenses 5,89,541. Total expenses borne by the first petitioner, that is 2,94,421. She has borne. She has spent from her pocket. But insurance claim was 5,89,000. Now, my lord, my submission, my humble submission is that, my lord.
According to you, you have paid 2,94,421.
Yes, 2,94,421 I paid from my pocket. But now, my lord, my humble submission, lord, your lordship may kindly see that at page number 15, every time, whenever we approach the hospital, we request him to bring his insurance policy also, because his insurance policy also covered. It's a group insurance policy. In that, 60% he can claim from his insurance policy. Now, my lord, entire my insurance policy around 5 lakhs goes to my child only, because I am also suffering with the goiter and some other problems. I cannot avail the insurance benefit. And my parents also, ailing parents, whatever the 96,000 rupees salary I am receiving, entire I am spending into for the treatment only, even for my livelihood, I am facing problem. He has got 1.5 lakh rupees salary, and also he has got group insurance policy from the company. That whatever the 60%, he can claim from his insurance policy, not entire from my insurance policy. That's what my humble submission, my humble prayer before your lordship, so that such an arrangement is made, whatever the 60%, let him claim from his group insurance policy. Whatever the 40%, let me get from the group insurance policy, so that the remaining amount I can utilize for my treatment and my parents' treatment. This is my humble submission. He will never, your lordship may kindly see at my application, along with my application, my document is page number 15. Whatever message I sent to him to bring, page number 15, document number 6.
Online. Whenever you want to come before the court, please come. That day we'll hear the matter, not today. When do you want?
Lord?
When do you want? When you can come to the court, then that day we'll hear it. Because this way it's not possible to decide the matter.
21st May.
Yes, 21st. Let's this matter on 21st.
Obliged.
Cell number 60. Rachita Rajshekar, petitioner. Rupesh Kumar S.
Let's see. No representative. Yes.
Kindly pass over minute. Senior is held.
Password. Password. List the matter on 25th, 24th.
Cell number 61. 61. R.S. Hegde.
Lord, I appeal for the petitioners. Yes.
Why? WP of 2017. Why should we grant time?
Lordship, may
No
I make one submission, my lord?
Yes.
Your lordship kindly. It was referred to the Lokadal at the instance of the other side, and matter is not taken up before Lokadal.
Let's see what is wrong.
1/4, the matter was referred. One 4/2025.
At request of learned counsel appearing before both the parties, matter is referred to Lok Adalat.
Oh, yes, madam.
Then?
It has not been, they have not given any proposal. The civil suits are
That's
also
why we
there.
will hear the matter. Please argue, both of you. Yes. Please argue on the merits.
Sir, please.
What is the impugned order?
My lord, the impugned order passed by the Lokadala, page 89, my lord. First petitioner is the wife. Second petitioner is the son. And on the memo filed by the...
Oh, is this a case where you were you are making allegations
Yes, madam.
that
Yes,
there is
yes,
something
madam.
has happened?
Yes, my lord. Some explanation is received, but I could not see it because the copies are not given to me.
You that?
And I applied for copies, and it has been said that that cannot be given to the discrepancy with regard to the signature of the advocate.
One minute,
Yes,
one
madam.
minute. Let me look at this.
ಇವಾಗಲ್ಲ.
Please.
They say that as per the report, the Lok Adalat was conducted on that day. What they say is Lok Adalat, even the notices were issued to the concerned. What they say is Lok Adalat was held on the day the judicial officer has signed. The advocate conciliator, as he was not, they've given the reasons. Then whoever is a clerk who has without even looking at that, it is not signed.
Not
has-
taken the signature.
No, without doing, even before doing it, she has issued the certified copy. That's what they are saying.
That is Milad.
And later, it was signed by the.
What I understand is Milad. As on the date of certified copy issued, there was no signature.
That's what she has issued the certified copy even before the order is signed by the advocate conciliator.
No,
For example, even here also in the Lok Adalat, now the judge will sign first, then the whoever is a member of the committee will be signing it later. So in between, if the certified copy is issued, that doesn't mean that no conciliation.
No, I am not, Milad.
That is exactly the allegation.
No, from the certified copy, I could see that.
No, first of all, you say that mediation is not done. For that, the answer is that a mediation is done. Lok Adalat was done, happened on that day. First of all, your ground is no Lok Adalat.
But
They say Lok Adalat happened. Then even now the memo is also issued to that lady who oversight, without even looking at the document, has given a certified copy. So by that, we cannot say that Lok Adalat is not, has not happened that day.
Milad, apart from that, the proceeding, you asked me kindly see, the proceeding initiated by the first petitioner wife in the year 2005, miscellaneous petition, initiated by the petitioners, wife and son for interim maintenance under 125 maintenance
No.
petition.
What we do is, please make your submissions with regard to this 2211. What is the date of order?
2212.
22?
12, Milad.
22/12/2000.
15.
2015.
So first your submission is no lok adalat. Then the other submission is no signature of the advocate conciliator. Then what is other submission?
No, no. Before that, my lord, before these 2 points, my lord, based on the certified copy, my lord, these 2 points are raised. But my lord, my responsible submission is the provisions of section 20 and 19 of Legal Service Authorities Act are not followed in the proceeding taken by the trial court. Your lordship will kindly see, kindly peruse.
No. There was a direction to agree for alimony of 10 lakhs to the petitioner on or before 30/4/2016. What has happened? Whether they paid?
No, it is
It has been paid,
deposited.
my lordships. It has been paid.
It is,
No.
Yes, my lordships.
It is
has been paid.
deposited, we have not received it. We have not received so far because we approached this honorable court and interim order of stay is granted. Now,
No, 34/2016 is the, what is the date? Date is on 22/12/2015 is the order.
yes, ma'am.
They were directed to be deposit the amount by 34/2016. When is this writ petition?
We have not received the amount. madam.
No, writ petition is on, what is the date? 25/3/2017 you have filed the writ petition. Please come to your affidavit or the grounds.
Before that, my lord,
So let me see, no, because already I heard this matter earlier, I remember.
annexure K may kindly be perused for a minute. Annexure K at page 89.
When the matter is not listed from 22/12/2015 to 25/3/2015, almost for a period of 2 years, you were not, what were you doing?
Please, your lordship.
The Lok Adalat award is on 22/12/2015.
15,
You have come before this court on 25/3/2017.
17.
So when
No,
did you come to
no,
know
no.
about this order?
No, only on coming to know, of the order, my
Now
lord.
please come to that affidavit
Yes,
filed
yes.
before the court, page number.
On coming to know of the order, my lord, I filed miscellaneous petition.
Where is that?
That is, my lord, I have produced miscellaneous petition. It is in Kannada.
Have you translated it?
Yes, I have
Page
submitted.
number?
Submitted, no, separate translation is submitted, my lord.
Translation of,
Affidavit, application and affidavit, translation copy.
is separately filed, it seems.
Lordship directed to submit a translation and I have submitted with a memo.
When is the date? Or if you have a copy, please pass on.
My lord, I could not immediately take that. I remember, I can see from the file. Because I remember I have filed before the court. There is no acknowledgement, I have filed before the court.
Yes.
Lordship may kindly pass over. I
Pass
will
over.
look
Pass
into.
over. Yes, call the next matter.
Sale number 62.
I appeal for the respondent in this matter, my lords.
It's reduce the sound. Yes.
My lords, I am under the instruction that the matter before the trial court has been allowed, my lords, rendering this
When is the date? When was it?
My lords,
You have any date?
kindly pass over the matter, my lords.
Pass over. Yes, next.
Sale number 63. 63.
Appear for respondent.
Kalyan Basavaraj.
Petitioner in this matter. Seek for an adjournment, my lord.
No adjournment.
Lord, this
No
is
matter will be adjourned. You have to argue, please.
This is actually an NOC
2019 matter,
wakalat.
our interlocutory application cannot be kept pending till 2025.
This is an NOC wakalat which we have filed, my lord.
We can't help it, Mr. Counsel. When did you file the NOC wakalat? When did you file?
Previous occasion itself I filed, my.
What is the include order?
Lord, as far as the instructions
Argue tomorrow, list the matter tomorrow, no further adjournments. We will not adjourn any of these old matters.
Kindly have this matter after 1 week.
Why?
Get senior counsel.
If both of you are not interested, I'll dismiss it.
We are ready today to argue.
Then tomorrow?
Tomorrow.
We are
senior,
ready today.
Yes.
Why not tomorrow?
Senior is out of station.
Today also you are arguing. Tomorrow also you argue.
Okay, ma'am.
Tomorrow is next.
Sale number 64. Appeal
My lord, for the petitioner, my lord. My lord, apologies for appearing through VC. Lord. The matter was referred to mediation and the matter is not settled.
Yes. Argue on the merits.
My lord. Indeed, my lord. My lord, the impugn order is annexure E, my lord.
Yes.
Page number 73 is the relevant portion, my lord. The petitioner is entitled for the visitation on every alternative Sunday for 2 hours between 9 a.m. to 6 p.m. as per the convenience of both the parties and without affecting the education and health of the child within jurisdiction of this court. Petitioner is also entitled for interim custody of the child on 50% of summer vacation of the child with prior intimation to the respondent and giving intimation regarding place of residence during such custody within jurisdiction and also entitled for phone calls and video calls, my lord. My lord, what we are seeking is enhancement of the visitation from 2 hours to 8 hours, my lord. My lord, till now, there's no visitation that has been happening.
What is the age of the child?
She is 16 years, my lord.
16 years.
16, my lord.
17 years. Mother is 17. What is she doing? Not she. We are talking about the daughter. Huh? 12th standard she is studying. From how long the parties are separated?
2014 is the separation, my lord. It's 11 years now, my lord.
What is the interim order in this? Interim order in this petition?
There's no interim order, my lord. Every time they go for settlement and they say that, we undertake to do the visitation.
When is the interim order date? This is on 7th August 2019. So what is continuing from 7th August 2019? Now I'll ask the GNWC itself to dispose of within 4 months. By December, I'll ask. Will not pass any order in this petition.
My lord, in the meantime, my lord, one request, my lord, let the visitation at least or a phone call happen, my lord. She is blocked through phone calls, video calls. We understand the child is in 12th grade. It's just that the father, there's a lot of parent alienation, my lord.
Yes. Are you complying with the order of the trial court?
Yes, but the thing is, the child is expressed the desire that she doesn't want to interact with the father for certain reason. And the trial court has recorded the certain reasons. What I produced it.
Trial court has recorded the reasons and passed an order. Granted some visitation. You have not questioned it. If you have not questioned it, you should have followed it.
Whenever the court directed notes were present, And she had
Please come to the operative portion of the order and read. Page number 73, please read. 73, operative portion of the impugned order.
Item number 3 filed by the petitioner is hereby for in part. The petitioner is entitled for visitation by on every alternative day for 2 hours between 9 a.m. to 6 p.m. as per the convenience of both the parties and without affecting the education and health of the child with the jurisdiction of the court. Petitioner has also entitled for interim custody of the child on 50% of the summer vacation of the child with prior intimation to the respondent and giving information regarding place of evidence during such custody within the jurisdiction of the court. Petitioner is also entitled for video call or phone call 3 times a week as paid for in the.
I'm asking you whether this order of the court is complied with or not.
She has complied with the law, but he never speaks to the child at all. And when the child met actually, just read the record, the binding recorded by the child court when after interacting with the child in camera proceedings. That I have produced for a moment, allow me kindly Peru. Allow me the memo I have produced.
No, the point is this, I'm not going to pass any orders on the merits of it.
Yes.
I'm directing the trial court to dispose of the matter. What I want to know is, have you complied with this order or not? If you are not happy with this order, what do you say?
No, my lord, it is not being complied with, my lord. My lord, whatever the memo that they are stating is completely different. My lord, they have not a phone call. My lord, yesterday was my daughter's birthday and I've not been able to talk to her.
Court is
You're not
granted.
willing to come 2
Court
weeks
has
once to
granted
India.
50% of the visitation, 50% of the summer vacation. Was it done? This is in the year 2019.
Lord, he resides in US law. And
No, then in that case, we'll do one thing. I'll ask the court to dispose of the matter, and whatever is the interim order, this order, it has to be complied with by the mother. If she is not complying with this, an adverse inference has to be drawn by the court and shall pass the order.
kindly Peru, the order passed by the time was not the impugned order. Lord, it was referred to mediation. And thereafter, Lord, the learned judge had interacted with the child since 17 years old. And he has recorded what exactly the child has expressed.
When is that? What is the date of that?
That is from 30th September 2023.
That we will go into everything. No, you are a party to this proceedings. There is an order passed. If you are not comfortable with this order, you should have come before this court, isn't it? You have not questioned it.
Lord, the child straightaway stated that she does not want to interact with the father because certain reason. Because that's what I wanted to point out. Lord, can you pass an order?
No, it's not that. That's not the way she knows when she's contesting these matters. Doesn't she know that for so and so reason, if the girl is not comfortable, either you have to comply with the order or that order has to be questioned. Without questioning the order, you just can't keep quiet and say that the girl is not comfortable. That should be brought to the notice of the court. Then what is the sanctity to the order?
That's what exactly I wanted to.
Not now. Not now. By questioning this order, you should bring it to the notice. No, if this is the way the litigant looks at the order, then all are like a paper orders. There is no sanctity to that. Then you have to come to the court and say that the girl is not interested. Mr. Counsel, you are understanding what I am referring. I am referring to the impugned order. I am referring to what is that you have done pursuant to this order. I am not referring to something what is happening in 2023. Is it not lapses on our part and simply keeping quiet, taking an order because under the guise that the girl doesn't want to see the father? That's not right. Whatever you are saying, that should have been said before this court. In 2019, you should have questioned this order. What is passed by the family court? And not tell the court now in 2025 that the girl is not interested.
Not now, not from the beginning.
Then why she has not questioned this order? That's what I'm asking. If the girl is not interested, you are aggrieved by this order. There is an order granting visitation to the father and also 50% of the visitor.
I understand that.
I'm only on that point, no, nothing else. I'm only asking you on that, nothing else. What is the conduct of the mother in this? Not questioning, because she's representing the guardian, the minor. She has to take care of her interest, but she can't keep quiet.
There is no allegation that the mother is actually encouraging the daughter to do all these things. There is no allegation of that at all.
Not questioning the order, not complying the order, both are not right.
She is mature, my lord.
Mature when, today or in 2014? 2014, what her age?
2023, my lord, that was the record.
Yes, sir. 2018, what is her age?
10 years, my lord.
10 years old. So 10 years old will not dictate what she wants in 2019. She might be dictating in 2017. That's not the, no, it is either the mother or the father, whoever it is, whatever, it's a boy or a girl, whoever it is, there is a procedure for everything. And they know everybody can't take their own decision, and they can't tell the court, no, not questioning this order itself shows that mother is happy with this order. Whatever subsequently in 2023 are happened, these are all subsequent events. No, either it has to be, either the order needs to be followed, or we have to, then there has to be some other order from this court. What is to be done now?
My lord, for the certain reasons that they are mentioning, my lord, they say that the child does not want to meet the father because he's asking her to study, pursue doctor. My lord, I am the father. Obviously, I'll ask the child to do something that I have done. It is her choice. But if they portray it as pressure, these are the reasons that they're saying why she does not want to meet the father.
So why are you keeping quiet from 2019 without doing anything? Because you're not interested to meet the child.
My lord, I have been blocked from all sorts of communication, my lord. My lord, till date, I have paid around 1 crore for interim maintenance, my lord.
You are remediless. When an order is there in your favor, are you remediless? You can't execute the order. So that means you are also not interested in executing that order.
Mother says, he has stopped paying the maintenance for the last 1 year. I remember that case. Because just because the daughter does not want to see him, he doesn't want to pay the maintenance.
Right.
He doesn't want to see the child.
You want an order from the court. You will take maintenance. You have an order from the court to comply with the visitation. That you will not comply. You can't blow hot and cold at the same time. Please come. Agree with orders passed in I number 3 in GNWC number 237 of 2018, dated 7th August 2019. The family court had granted visitation, whereby the father is entitled to the visitation on every alternative Sunday for 2 hours between 9 a.m. to 6 p.m. as per the convenience of both the parties and without affecting the education and health of the child. The father is also entitled for interim custody of the child on 50% of the summer vacation with prior intimation to the mother and giving intimation regarding place of residence during such custody within the jurisdiction of the court. And the father is also entitled for video calls or phone calls 3 times a week. And the same should be a reasonable time with prior intimation to the respondent. Seeking enhancement of the maintenance, the father is before this court. Now the land counsel appearing for the father submits that the respondent, the father could not exercise a visitation And even the father is blocked and is not even through video, even through the phone calls also, he is not in a position to contact the to talk to the daughter. Then counsel appearing for the mother submits that the daughter is now 17 years old and she is not at all interested to meet the father. The same thing is expressed by her and that is recorded by the court. Next for having got the counsels on either side, where is the material on record. This is a writ petition of 2019. From 2019, there are no interim orders passed by this court. There is an order passed by the family court. Why the father has not executed, has not taken steps to get that order executed is not known. When it comes to the mother, when she filed, when an order is passed, and according to her, the daughter is not interested to meet the father, and there are any other compelling reasons why she has not questioned the order impugned is not known. It is very unfortunate that when the orders are passed by the not that when counsel submits that the father has failed to pay the maintenance, is not paying the maintenance from the last 1 year. That order of maintenance is also passed by the court. When the mother is enjoying the fruits of an order passed by the court, and she has every responsibility and should have a respect towards the order passed by the court, where visitation is granted by the court, then if she is not able to comply for any of the reasons, she should have questioned that order. No, this attitude on the part of the litigants, it has become a norm that what is convenient to them, they are following. What is not convenient to them, they are not following. The family court shall look into this aspect also. And if the court feels that there is violation of the order passed by the court should take appropriate steps to if in terms of visitation, if it is not possible, then in term shall quantify the cost for such behavior from the litigant, and in while disposing of the GNWC, the court shall look into all these aspects. This is a GNWC of 2018. The family court, the 6th additional principal judge, family court Bangalore, shall dispose of this petition by December 15th. Yes.
My lord, one thing, my lord. My lord, the reason why execution was not filed is because then the visitation, every time they go for a settlement and they say, no, we will do at the convenience of the daughter. And we challenged this in 2019 only, my lord.
Yes. Next.
Number
Much obliged.
65. Disposed of.
Petitioners, my lord. My lord, this is challenging the maintenance order, my lords. The trial court has impugned order at page number 15, my lords.
Where is the impugned order?
At page number 15, my lords.
What is the amount granted?
My lords, 10,000 is amount is fixed, my lords. The trial court has failed to consider the aspect that, my lords, I was working as a music teacher, my lords. I was driving only 10,000 salary, my lords. With respect to that, I have produced my appointment letter and income tax returns, my lords. That was not considered.
The order is already modified to the effect that.
Yes, my lords.
What is the earlier order?
Earlier it was 25,000, my lords. Based on that, I approached Honorable High Court, my lords, in writ petition. Then the High Court revert back the matter to the trial court. After modification, the trial court fixed 10,000, my lords.
According to you, that is also on the highest side.
Yes, my lords.
Who are the respondent? Only wife or the child is also there?
Only wife.
Only wife, my lords.
So please come to the reasoning given by the court. Come to
My lords, may I please make a mention here? The first petition, what is listed, my lords, I'm not on record. It appears that the party has not given wakalat to anybody. That's what the instruction I received now. In the companion petition, I am the respondent, my lords.
You will say that you are instructed to, you shall appear before this, for this.
If permitted, I will submit on that issue, my lords, because wakalat is not on record.
The
please.
so-and-so on behalf of the wife, WP number 21516 of 2021.
No, that time there, my lords.
That's what I'm saying.
The very first one,
Understand.
550.
Is filed by the wife in the first petition for the respondent.
Yes.
So and so is directed to take notice. Yes.
My lords, in this connected matter, my lords,
I'm not going to the connected matter. In your matter, please come to that
please,
issue in
my lord.
order.
My lords, at paragraph number 9, my lords, the appointment letter 28/2018 produced by the respondent is the document subsequently obtained. Since the petitioner has seriously disputed the authenticity of the genuineness of the appointment letter dated so and so produced by the respondent, it cannot.
Who is the petitioner? Who is the respondent here?
Here, petitioner is a husband, my lords.
Before the court, who filed the MC?
MC is filed by the wife, my lords.
Wife. So appointment letter produced by the respondent. Whose appointment letter? Wife's appointment letter?
No, my lords, my appointment letter. Like I was appointed as a music teacher and drawing at 10,000 salary, my lords. And
Next, read paragraph number 10.
The income tax returns produced by the respondent to show that his income of the year 2015-16 is 8,26,579 rupees, and year 2016-17 4,69,000, year 17-18 1,01,059, for the year 18-19 31,000, for the year 19-10 11,000, my lords. The income tax returns is not a proof of the actual income because the parties will always hide their income to avoid the tax. The respondent has not produced his bank statement.
Why the income has come to 11,000 in 2019 and
My lords, earlier I was working in a Deloitte, my lords. After these series of cases, my lords, I left the job. I was working as a music teacher, my lords.
He's admitting that he left the job. He's admitting that he's left the job because of the proceedings, my lords.
In the year, my lords, 2015, the MC has been filed, my lords. This order has passed in 2019, my lords. Before filing up the MC petition only, my lords, I left the job, my lords.
And after that, you don't want to do the software job?
No, my lords, since I was dealing with a number of cases, my lords, there are 3 cases pending, my lords, before the family court, 1 MC and 2 executions regarding the GNWC, my lords. Before this high court, my lords, these 2 writ petition and MFA regarding the GNWC, my lords, and 1 DV case is dismissed filed by the wife, my lords, and criminal appeal is also pending, my lords.
Which year is this IA?
2019, my lord.
Itself is of the year 2015.
Yes, my lords.
We'll ask the court to dispose of the matter. No, because anyhow it's pending till now.
Please.
What any interim order is there in this?
No, my lords. In the connected matter, my lords, that was challenging the trial court struck off my defense, my lords. I challenged that in second connected writ petition, my lords, wherein this honorable court, my lords, passed an interim order, my lords, stating to deposit 35% of the arrear maintenance, my lords, and 7,500 maintenance per month, my lords. Till today, I am paying all the maintenance, my lords, but my wife is not showing the child's face, my lords. No visitation right complied with by the wife, my lords. Even at the time of passing the interim orders, my lords, I requested this honorable to consider the visitation rights, my lords. In the order dated.
Where is the application filed by you for visitation?
Please, my lords.
Where is the application filed by you?
No, my lords, application was not filed in this.
Just like that, whenever you ask, court will consider that.
No, my lords, in the order sheet it is mentioned, my lords, the request of the petitioner to interact with the ward in question will be considered after the petitioner complies with the interim order.
Court might have said that.
Please, ma'am.
How can you ask for all that? Can't you file an application for that?
But MFA is pending, my lords. In MFA, my lords, in the last month, the child, wife, husband, all are present, my lords. The double bench, my lords, they have directed the child to go for a counseling before the demands, my lords.
Like because she is not interacting.
Yes, my lords.
So now what is the purpose of passing another order? Already you have the division bench has passed an order.
Please, ma'am.
Yes. So let the court, the main MC itself be disposed of with the same condition of 7,500.
My lords, 7,500 is very less because, my lords.
Let the court decide because it will be decided by December 15th.
May I please make one more request? My lords, in the companion petition, I had filed an IA seeking striking of the defense, my lords, because he has not complied with the maintenance order. Now, I will leave it to the discretion of this honorable court if my lords is inclined to permit him to lead evidence, but only that a time frame may be fixed because the 2015 matter.
I'm saying December 15th.
Please,
By the main MC itself be disposed of.
please, my lords.
Yes, that
Yes.
will serve the purpose, not all these applications.
Please, grateful.
So agreed by the order. First you take this in.
My lords, the assigned liability is also not filed, my lords, by the wife and by wife and husband.
There we will do it, my lords.
Whatever you have to do, you do it. No adjournments will fix a time frame. Court will not grant any time for you because all these matter. This is the MC of 2015.
15 month. My lords, I am paying 7,500 per month, my lords. That may be reduced, my lords.
No.
Till today, I am paying, my
It
lords.
will not be reduced. The first of all, WP number 50738 of 2019. Take order in this. The questioning the order passed by the family court in I number 8 in MC number 4610 of 2014 dated 99 September 2019, whereby the family court had granted maintenance, reduced the maintenance to an amount of rupees 10,000. The husband is before this court. When counsel appearing for the husband submits that earlier he was working in Deloitte. He was working in Deloitte.
Yes, my lords. Earlier,
Working
before
in
the
Deloitte
MC.
and now, in view of all the pending cases, he left his job and now he's working as a piano teacher and his income is 10,000. Court, without considering the said fact, had granted maintenance of an amount of rupees 10,000 and the petitioner is not in a position to pay the amount. Then that also, WP number 50738 of 2009. WP 21516 of 21. WP 21516 of 2021 in the first para only, right, is filed by the husband questioning an order passed by the court whereby as he has failed to pay the maintenance, court has struck off the defense of the petitioner of the husband by order dated 9th November 2021. Whereby the court had allowed the application filed under section 151 of the CPC. The defense set up by the respondent in the objection statement is struck off. Agreed by that, the said writ petition is filed. In that writ petition, give the order sheet. In that writ petition, an interim order is passed by the court on 30/11/2021, subject to the husband paying 35% of the arrears of maintenance, that is 15% within 2 weeks, another 15% within next 2 weeks, the remaining 5% within 1 week, the following that, and further he shall continue to pay 7,500 per month on or before 5th of every calendar month. Both the counsels submits that the said order passed by this court is complied with. According to the learned counsel for the petitioner, the respondent has not filed the statement of assets and liabilities. According to the is not filed, and according to the learned counsel appearing for the mother, the amount that is granted by the court is on the lower side, and the petitioner and the wife is not in a position to take care of herself and the child with that meager amount. Next part. The writ petition, the MC is filed in the year 2015. With all this litigation, the court could not even dispose of the main MC even after 10 years from the date of institution. Considering all these facts, this court feels that no further orders needs to be passed in this petition, and a timeline shall be fixed to dispose of the main MC, where all the disputes between the parties can be decided by the court. Hence, this court is passing the following order. Both the writ petitions are disposed of by directing the family court to dispose of the matter by December 15th.
My lords, next date is on October 8, my lords.
Once this order is there, it will again bring it to the room by December 15th. Within 15 days from the date of receipt of the copy of this order, both the parties shall file their fresh statement of assets and liabilities. The court shall fix a time frame and None of the parties shall ask for adjournments, and the court shall not grant any adjournment. The interim order that is granted by the court with regard to 7,500, that shall continue till the disposal of the case.
Yes. So grateful, Manoj.
Cell number 66, Dheeraj JK.
Yes.
Mutual divorce petition was filed in the year 2007, my lord.
Mm.
The petitioner was agreed to pay.
Where is the impugned order?
Impugned order is annexure J1, my lord.
Page?
In page number
12, running page 12.
160, my lord.
Page number?
160. I am for the husband.
1 minute, let me look at the impugned order.
In that execution number 6 of 2009, in that case,
An application under section 47 is filed.
please,
By
for
whom?
closure of the petition, execution petition.
No.
Without
When
payment.
was the mutual consent divorce?
2007, my lord.
2007.
10/7/2007.
Annexure
10/7?
2007.
As per the mutual consent divorce,
in
what are
page
the
number
terms of
30.
what are the terms of settlement
Maintenance 10,000 maintenance has to be paid to the
every month?
Each
Every month.
5,000 to the wife, 5,000 to the child.
That has been order has been passed by this one.
Let me complete my word.
Oh.
Lordship, after consent divorce, my lord, that the wife of the petitioner was remarried. Without filing on behalf of the child, she herself has filed an execution petition claiming the total maintenance of rupees 10,000.
He remarried.
In the year 2009 itself, 9 or 8, 2009.
So where is the execution petition?
Your
Let me
Lordship,
look at
kindly, it was observed in the order.
No, before going to that, I would like to look at the execution petition that is filed.
2009.
Page number.
Page number, my lord.
Petition copy is not furnished.
Page
Only
number 23, my lord. 23 is the execution petition. Page number 23, my lord.
Let me look at it.
Annexure B.
No, please come to page 24.
Please, my lord. My lord, one thing I want to bring to your kind notice. One thing is that there was an order to pay maintenance of rupees 10,000 each, 5,000 to the wife and 5,000 to the child, as well as the visitation rights was granted again to the petitioner. So far as both the petitioner, husband and wife, have violated the order.
Then
She was not permitted to visit the child.
no.
Then he has refused to pay the maintenance.
That can't be.
Again, they have filed one more execution petition filed by the husband.
Yes.
Connecting the both the execution petition, that the honorable trial court was pleased to
In the compromise
pass a
decree,
common order.
in the compromise decree, if there is violation, you will file. If there is violation on your part, she will file. Now, what is this section 47 CPC petition that I didn't understand?
Lordship, may kindly see.
No, you say that in 2007 she got married.
Please.
You are liable to pay the maintenance of 5,000 to the child. So, from the date of mutual consent divorce till now, what is the amount you have paid?
Your Lordship, may kindly one thing, another order, this honorable court was pleased to pass order on 30th January 2023. As on this day, that the entire amount has been passed,
no,
paid.
as per the direction of this honorable
Re.
6 lakhs has been paid.
6 lakhs have been paid.
As
It
per
was
the document.
calculated up to 2023 because 2017 itself that the child was attained in majority and he is working in Australia.
No, still he is studying.
Your Lordship may kindly see the order dated 30th January 2023.
Both the councils shall file a calculation memo as per the.
As on this day, no.
That's what, please file
Please.
it. As per the compromise memo file, till today, what are the arrears? What is the amount? What are the arrears? If there are any arrears, if any, both the councils shall file the calculation memo. The calculation memo shall be filed by 30th by serving in advance on both, by serving on both, on the councils. List the matter on 4th of August. We will pass
Lordship,
final
insofar
orders.
as my side is concerned, there is no
You can file
amount
it.
have been due.
That's
I am
why-
going to file a memo for calculation as a nil only.
Yes, file it. I'll decide it on 4th.
Please.
Yes. Yes, next.
67. Cell number 67.
I am for the petition in this case.
Power date, Loda.
My lord, the respondent had filed 498 case, my lord, and then I had filed a divorce petition. In that divorce petition, my lord, she had filed application for maintenance. On that, I have approached this honorable court. My lord, that divorce petition is disposed of. In the meanwhile, my lord, she filed a maintenance petition. That
This petition
Yeah,
is
yes.
arising out of an IA from the MC.
Yes, yes, yes.
That MC
That
is
is
disposed
disposed
of.
of.
When
And
is that?
in the meanwhile, my lord, this honorable court has ordered by granting a stay, my lord, 5,000 ಕಟ್ಟಬೇಕು ಅಂತಿತ್ತು. And
Whatever it
yes.
is, when is the MC disposed of?
MC disposed of, my lord, in 2024, 5/9/2024.
On 5/9/2024.
But one submission, ma'am. On the said order, my lord, I was paying 5,000 per month to her in another criminal misdemeanor, my lord. Hence, my lord, the same order may be retained. So that based on this writ petition, my lord,
Order when the MC, that order has culminated, this order has culminated into the final order.
but this order have
We cannot pass anything.
I have presented
It
the
is
same order,
submitted
ma'am.
that on 5/9/2024, the MC number so and so. What is the MC number?
165, my lord, of 19.
There is an impugned order. MC number 165 of 2019 is disposed of on 5/9/2024. Hence, when the main writ petition is, when main MC itself is disposed of, there are no further orders required to be passed in this petition, which is arising from an interlocutory order. In the light of the same, the writ petition is dismissed as infructuous. Yes.
Cell number 68.
I appear for the petitioner, my lord. The next map, 68.1, not I am the petitioner. Now both the husband and wife have challenged the order of the trial court passed under section 24 of the act, my lord. On 10/1/2025, my lord, the main matter is disposed of.
10/1?
2025. MC number 5122 of 13 is disposed of, my lord.
MC number?
5122 of 13.
Both these writ petitions.
One
are filed.
submission, my lord. In my writ petition, apart from the, I have sought from not enhancement. One more, my lord, the contention was, not instead of passing the order from the date of the application, not the trial court passes the order, not from the date of argument. That is the only, my lord.
That cannot be
To
corrected.
that period, my lord, I am entitled. That is the only,
That
my lord,
cannot be corrected.
contention remains,
No, we
my lord.
cannot correct that order.
That the
because
reason, my lord, is there has been number of negotiations not before the Lok Adalat as well as before the mediation center, my lord. That was the reason, my lord, the parties could not
both the
address
writ
the argument.
petitions are disposed of by way of, but both the writ petitions are arising out of the IA where maintenance is granted in MC number 5122 of 2013. The said MC itself is disposed of on 10/1/2015. As this is against the present writ petition is against an interlocutory order. Nothing survives for consultation in this writ petition, and accordingly, both the writ petitions are dismissed as infructuous. Yes, next 69.
Cell number 69.
10/1/25, my lord.
10/1/25.
Please.
25. 10/1/25.
69.
This petition, my lord, the interim of allowances for the tune of 10,000 per month, my lord, by the wife.
Where is the
And
counsel for
she
the
is working as,
respondent?
please, it is in page number 55, my lord.
Is held
Order.
sufficient.
Yes. She placed it expert. In page number 55 is the order, my lord. It was
50?
ordered for 10,000. She is working as a teacher in the same school where the child is studying. And with respect to the fees and everything.
Let us read the order.
Please.
From the reasoning part.
Reasoning part, my lord, please.
53.
I number 8, can I read this?
I number, read.
Please. IA number 8 is filed by the respondent seeking interim maintenance in sum of rupees 25,000.
Who filed the MC?
Please. Filed husband, the petitioner. 25,000 per month and 10,000 towards the litigation expenses. In the accompanying affidavit, it is stated that the petitioner husband has deliberately failed to maintain the respondent and her female child, Bhuvana, aged 10 years, and has not provided any maintenance for herself and for the education expenses of the minor daughter. It is further stated on oath that the respondent is not having independent income to bear the fees and other expenses of the child and also to maintain herself. Regarding desertion and other things are stated in the affidavit, which will be considered in the appropriate time. In this case, marriage and birth of the child is admitted by the petitioner in the petition by him. At this juncture, as far as soon education expense of the child and basic need of the child is concerned, I feel it is proper to pass an interim order pendent late. In this case, both the parties have not filed assets and liability statement. Taking all the above into consideration, I feel that the petitioner is bound to meet the education expenses of the child and he is liable to pay interim maintenance pending lit of the 10,000 per month from the date of application till disposal of the petition on merits. Further, the petitioner shall pay on one-time litigation expenses of 8,000 to the respondent. Hence, I following order. IA number 8 is here partly allowed as under the that the petitioner shall pay interim maintenance pending lit of 10,000. My lord, here she is working as a teacher in the same school where the expenses of legal educational expense will be waived off. She is working as a teacher. That will be in the they will produce the documents in the evidence, my lord. He is now working because he is under medical treatment, my lord. Husband is medical treatment. That's why
What was his
10,000.
salary as on that day?
Please.
What was his salary as on that day?
No documents has been no asset and liability
At least
produced by
you should
both
be
the
able to
parties.
say what is his salary.
My lord, no documents has been produced.
No, whatever the maintenance that is given to the child.
Please, but as per in the case, my lord, she is working as a teacher in the same
Yes,
school.
she is working. She
But
will spend.
school fees
also
were waived
supposed
off,
to
my lord.
spend.
School fees were waived off to the child because she is a
Then
teacher.
if the school fees waived, then how there are no other expenses to the child?
It is only educational expenses, my lord. She sought for only educational expenses. This is the only petition for. Okay, I agree, but 10,000 is too high, my lord. Please.
Where did you say that the educational expenses are
No,
taken
my
care
lord,
of?
it is not now. It is at the time of evidence in the cross-examination or documents have to produce. It is stayed till. In this petition, the interim order has been passed. That's why.
Now, what happened to the MC?
MC is still pending, my lord.
It is stayed by this
Yes,
court.
pending. It is for evidence. But 2002 experiment, the child is also, it is too experiment. At this juncture, my lord, 10,000 is too much.
You should say, what are the expenses? Why is it high? No, mother is working. Mother will take care of the boy. You also, it is your responsibility. You are not giving
Please,
maintenance
yes,
to
I
the
agree.
wife.
I agree, my lord.
Yes.
Please.
So, what was your salary as on that day? Why do you say that 10,000 is on the higher side? That should be your answer.
Please, but my contention is the fees were waived off, and there is no particular. She has not produced in the salary certificate also. Even I am not a producer, my lord. It is pending for evidence.
So let the court decide. Let this order be. Let this order continue. Is there any stay by this court?
Yes.
How much is order directed to be paid?
7,000.
Then continue to pay that and let the court
Even
decide.
7,000 also very much.
Because it is 15. No. This is an MC of 2017.
Please.
This matter also we have directed all these matters by December 15th.
7,000 also to exhibit.
No, you are paying.
No,
You are paying by an interim order. Continue. Because where are we? We are in July, August, September, October, November, December. In 5 months, it will be disposed of. The agreed with orders passed in. What is this IA? Where is the order?
55, my lord. Yes, page number 55.
50?
5.
Agreed with orders passed in IA number 8 whereby the court had granted 10,000 per month as maintenance to the wife. The wife is before this court, the husband is before this court. Land counsel appearing for the husband submits that wife is also working in the school and all the expenses that she need not pay the education expenses to the child. And the court granting 10,000 maintenance is on the higher side. When this matter came up, at the time of initially this court has granted, where is that order? By order dated 2/12/2021, this court had directed the husband to pay an amount of rupees 7,000 on or before 5th of every English calendar month without fail, and shall pay 50% of the arrears of maintenance within 4 weeks, failing which the interim protection granted shall stand decided on its own. When counsel for the petitioner submits that they have been complying with the interim order, but still an amount of rupees 7,000 is on the higher side. The notice to the respondent is held sufficient by order dated so and so. By order dated, look at that, 13/8/2024. Notice to respondent is held sufficient. Next para. Having heard the counsel for the petitioner, there is a material on record. The MC is of the year 2017, pending on the file of the 4th Additional Principal Judge, Family Court, Bangalore. Right from the date of order till now, the petitioner is paying 7,000 to the wife. On the same condition, and as this is a old matter, this court deems it appropriate to direct the trial court to dispose of the matter, and the petitioner shall continue to pay the amount. Accordingly, the writ petition is disposed of, directing the family court to dispose of this matter by December 15th. The parties shall not ask for unnecessary adjournments. The court, without granting adjournment, shall dispose of the matter. The petitioner husband shall continue to pay 7,000.
Please.
Yes, after lunch.
Your Lordship, kindly, one submission, madam.
Yes.
English translation I could not find, madam. I will file it. A week's time, I will file it.
This matter, at any cost, we have to dispose of by the next date of
No,
hearing.
I will certainly.
List this matter on 22nd. By the time the English translation of the petition, that is execution petition. No, what is
Application and
that?
affidavit.
Miscellaneous petition.
Application and affidavit.
Shall be filed. Yes.
My lord, serial number 58, handle. Monday is the case, my lord. NBW is issued. Serial number 58. NBW issued, my lord.
So, I'll hear the matter after lunch.
Interim order has been passed in the serial
And
number
delivery
58.
you want. Yes.
Please, ma'am. Watch out.
Serial number 3, the matter is settled without the parties in ended with divorce. Therefore, I have
1 minute, 1 minute. Take that hand delivery thing. Yes. Which one?
Serial number 3.
First, serial number 3.
In this matter,
Take that.
the dispute between the parties is settled and is closed in MC. Therefore, the petition may be dismissed as not pressed.
What happened to that?
He has given memo that there is a condition order to deposit the money and
Yeah,
that is passed to warning only is not for dismissal. Yes,
Oh, that's fine.
Yeah, the interim order is complied in earlier. I was not due.
The MC itself is disposed of. That's why you,
Yes, divorce is granted.
it is submitted that the main MC is, the memo is filed stating that the main MC itself is disposed of, and so nothing serves for consideration in this petition accordingly. No, this is arising out of RPFC number. This is arising out of RPFC.
The dispute
No,
between the
I'll
parties.
see it. That's why it is passed over. I'll see
The
it in the
dispute
after.
between the parties is settled.
See, we'll see. I have to look at that MC. Huh?
Serial number 87.
No mentionings now.
And the memo capital amount. ಅಲ್ಲಿ hand delivery memo kept below. 17.
Court officer.
ಹೇಳಿ ಸರ್. ಹೇಳಿ ಸರ್.
50.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಏನಾಯ್ತು ಮೇಡಮ್? 50.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಟುಮಾರೋ ಆಗಿದೆ ಅದು. ನಾಳೆಗೆ ಡಿಸ್ಮಿಸಲ್ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಮಧ್ಯಾಹ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ ಮೇಡಮ್ ನಾನು?
ಫೈಲ್ ಎಲ್ಲ ಒಟ್ಟೋಗಿದೆ
ಓಕೆ
ಸ್ಟೆನೋಗ್ರಾಫರ್.
ಮೇಡಮ್, ನಾಳೆ ಇದು ಮಾಡ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು.
ನಾಳೆ ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲೇ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಅಂಡರ್ ಡಿಸ್ಮಿಸಲ್ ಕ್ಯಾಪ್ಷನ್.
ಓಕೆ, ಅಪಿಯರ್ ಆಗ್ತೀನಿ ಮೇಡಮ್. ಆಗಿದೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್
ಮ್ಯಾಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 77.
ಮೇಡಮ್ ಈಗ ಒಂದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ ಕೊಡಿ ಅದು. 77 ಏನ್ ಬೇಕು?
ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ? ಆಯ್ತು ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಕದಿತೀನಿ ಎಲ್ಲ ಕೇಸು ಕದಿತೀನಿ.
passovers.
Passover matters. Serial number 3. Mic use ಮಾಡಿ sir.
Mic, switch on the mic.
The dispute between the petitioner and the respondent was settled in MC.
When you start?
There more than 2-3 months back.
MC is a different aspect.
It is not a.
This is RPFC. That is, this is not arising out of a writ petition.
Yes, yes, yes.
This is a RPFC.
Yes, RPFC.
So how the rights of the parties are decided? And now you have enjoyed an interim order from 2022. Now you want to withdraw. What is happening? That we have to know.
That interim order was passed by this court as a complied before the trial.
What are your instructions?
I don't have an instruction, my lord. Kindly after Monday I will make our submission, my lord. I don't have a party phone number, my lord.
This is matter on Wednesday.
Yes.
Yes, next. Yes, next.
Serial number 4.
Yes, in this case. What happened?
We discussed with it, my lord. We discussed and he agreed another 50,000 till July 2025. They are supposed to pay another 50,000, my lord.
He has also agreed. Land council both the council submits that an amount of rupees 50,000 is due as per the orders passed by as per the interim orders passed by this court till July 2025, my lord. Till July 2025. And when will he pay?
Your Honor, we will pay on 10th August. After 10th August.
Lord, just 10,000 they've been paying for wife and girls of 11 years old, my lord.
We are not going into that. First of all, let him comply with the order.
Till the order of this court, we have paid.
That they will be paying this amount by 15th of August. This matter on 18th of August. Yes, next.
Stay, extension of stay.
Interim order, all your granted is extended till then. Next.
Much better.
As the money is already paid, that extension petition is ordered and we shall pay the amount by so and so. Yes.
Serial number 38. Serial number 38. Let it be for petitioner. Rakesh Kini.
Kindly pass on, my lord. Senior is
How many
coming.
passovers you want? Morning already passed over.
Last person. Senior is coming, my lord. 5 minutes.
Lords may kindly consider the application.
That's for that only I've given time because I want to discuss it. Call your senior.
Yes, ma'am.
Yes. Keep the matter.
Yes, ma'am. Serial number
Yes, ma'am.
62.
50?
62. 62.
For the petitioner, my lord.
For the respondent, my lord.
Impugned order is page number 25, my lord.
Yes.
One short submission. The MC is disposed, my lord, on 11th of February this year.
11th February?
Yeah, I'm furnishing the copy of judgment.
Yes. Take that. The land council appearing for the respondent has placed before the court the judgment that is passed in MC number 22 of 2017 dated 11th February 2025. Considering the fact that the MC itself is disposed of, nothing remains for consideration in this petition. Accordingly, dismissed. Next.
Much obliged.
Next, continuation of this.
Yes.
Serial number 70. Sangeeta Reddy. Petitioner.
The petitioner name is printed.
Because I think.
Is that? On 26/7/2024, this court had passed an order observing that land counsel for the petition has filed a memo for retirement stating that the client had addressed an email dated 8/8/2023 requesting the counsel to file memo for retirement on the cases which is pending before the court. and accordingly, he has filed a memo seeking permission to retire from the case. And this court has perused the email and has permitted the counsel to retire from the case. And this court has directed to delete the name of the counsel and to print the name of the party. Thereafter, no advocate is engaged. The petition has not engaged an advocate nor appeared before this court. Accordingly, the writ petition is dismissed for non-prosecution.
Cell number 71 adjourned. Cell number 72. N. Gautam Raghunath.
This is also along with the other matter. Yes, next.
Cell number 73. Okay. Sneha A. Kallar.
For the petitioners, Your Honor. This is a matter of enhancement, my lords. Page number 25 in annexure A.
Page number?
25.
How much is the amount granted?
5,000 rupees per month to the petition number 2 daughter and 10,000 rupees litigation expenses.
Who appears for the respondent? The counsel for the petitioner is present. No representation for the counsel for the respondent. List this matter on 29.
My lords, if I may, there has been a pattern wherein they haven't appeared.
That's
even
why
after.
on 29 this matter will be listed. That day, whether they are not there also will be part.
Please.
An opportunity should be given. Yes.
Cell number
Highly obliged.
74.
I appear for the respondent.
I appear on behalf of the petitioner. But in this matter, Lordship had heard this matter on several occasions earlier. This is a matter in which, where the father, that is the husband's petition for divorce, which is pending before the court, and by way of an interim order, maintenance is granted to the respondent wife. The husband earlier at the time of the application was earning about 1 lakh per month. The trial court proceeded to pass an order of 1 lakh maintenance to the wife. I approached by way of writ petition, this writ petition to this honorable court. The Lordship was pleased to pass an interim order reducing it to 10,000 per month. Thereafter, there is a revision in his salary. He approached the employer. He sought revision. By way of an affidavit, I filed my latest salary slip also. His salary slip says 4 lakh, but his take home is 2 lakh. Considering that point of fact, the Lordship has passed an order on 10/9/2024. That is, this affidavit is filed with regard to the salary certificate and is taken on record. The learned counsel appearing on behalf of the petitioner submits that the wife is staying in the house which belongs to the petitioner. I have given my own house to her and I am staying on rent along with the daughter, and the petitioner is taking care of the son. According to the petitioner, he is paying all the expenses, educational expenses, and the petitioner is always ready to take care of the expenses of the 2 children. He submits that the trial court granted an interim maintenance of rupees 1 lakh, which is on the higher side. According to him, as of now, his take-home salary is 1,93,000 per month. The learned counsel appearing for the respondent does not deny the fact that the wife is staying in the house which belongs to the husband. When it comes to educational expenses, he submits that he has no specific instructions whether the petitioner is paying the same or not. To this effect, I have filed a memo of calculation along with the receipts, which Your Lordships have taken it on record earlier. He submits that the court had rightly granted the maintenance to the tune of rupees 1 lakh as maintenance. Looking at the fact that one child is with the father and he's living in a rented accommodation and he's taking care of that child and he's to take care of himself and other responsibilities. This next one, my lords, when the mother was working from the last 4 years, why she had to quit the job at this point of time, and the reason that is stated by the learned counsel for the respondent is not convincing. After I filed this writ petition, Your Lordships noted that she's earning 40,000 per month. Now she wants to treat me like a cash cow. She resigns from her job, and Your Lordships have directed them to explain as to why she quit her job after this writ petition is filed. Thereafter, matter was taken up on 3 occasions. They did not.
Where is the anything is filed after this?
Nothing, my lords.
Yes,
that needs to be heard.
My lord, may I submit, my lord, he has come up before this honorable court against an interim order. My lord, the trial court, he has not filed objection. He was called upon to file the assets and liabilities. 3 times time was granted. He has not filed before the court below.
No.
That's the reason, my lord, the trial court has given. Now you have put your law.
This court has passed an order directing the respondent to file certain, what is that? What are the expenses she is incurring for the child and why she had quit the job. The husband also shall file receipts of the school fees that he has been paying. What did you file after this order?
My lord, I submit, my lord, of course it is. I am not justifying. What has happened, my lord, it is come by consent. Later I came. I read the order sheet just now. Your lordship is right. She has not filed the expenses. But only thing, my lord, she has filed the objection statement in which it states that she had to leave the job because she had to take care of the child. Before that, my lord, can I request your lordship to see para 5 of the affidavit filed by the other side? Lordship got it, my lord?
Yes. Yes.
I submit that the salary certificate produced on Annex G is for the month January 2024, wherein the gross earning is rupees 4,27,971 per month. The basic earning is at rupees 2,13,986. House rent allowance is at 85,594. Telephone allowance is 5,000. Professional membership 1,500 and special allowance is at rupees 1,21,000. I submit that there is deduction in my salary rupees 3,52,880. Could it be justified, my lord? 4 lakh salary, he says deduction is 3,52,000.
I'm sorry to interrupt.
My lord, he can't be imaginary deductions.
Deduction is 25,000, professional tax 200, income tax 2,52,750. Every month you pay 2,52,000.
Sorry, my lords, every month towards, I'm sorry, my lords.
Income tax every month 2,52,000.
No. I've explained it stating that.
At paragraph number 6.
Please. Please, my lords. Well, at paragraph number 11, I've explained of that same affidavit.
First of all, explain what is.
Well, explaining that point itself in paragraph number 11, I pointed it out why 3,25,000 was deducted towards tax. For that particular month alone, I've explained in paragraph number 11. If I may read, my lords. I submit that on a monthly basis, income tax is deducted at different percentages. During the months of January, February, and March, the employer makes up for the pending taxes remaining to be paid. In other words, during some quarters of the financial year, the employer may deduct 25% towards the income tax and to make up for the remaining tax of surcharge, because my CTC comes beyond 50 lakh. This add a surcharge of 5 plus 10%. That's a statutory deduction. And that is how in that particular month, right after which I filed my revised salary slip, which is on record. This is the old salary slip, which I gave an explanation.
Maximum is 30% slab. It can't be beyond that. Out of 4 lakhs, it can't be 2,52,000.
Same affidavit itself, I filed my revised.
Avoid paying Mellor, that is against it. In fact, Mellor, there are 2 decisions. I'm sorry, I could not. One is by Justice Nagprasanna Mellor. One more decision. He can't deduct. Only PF he can deduct on the professional tax. And he can't deduct Mellor for the other things. Mellor, I'm sorry, I was not able to. 2 judgments of this honorable court. He can't deduct.
These deductions are not by me. In hand, whatever I get, there's a salary.
Relying upon the Supreme Court decision, Mellor, they have got the judgments.
My salary is not to the tune of 2 lakhs.
Pass on the judgments, Mellor. I'm sorry. Could your lordship have it tomorrow, Mellor? I will myself appear in person and give the copy. Your lordship wanted to. So it will be my pleasure to appear, Mellor, and appear in person.
Tomorrow.
Please.
At the request of the counsel for the response. Yes, 75.
Cell number
As
75.
interim order may kindly be extended.
Interim order, all granted.
75. Babu TC.
Appear for respondent in this matter.
Yes. Yes.
My lords, I am before this honorable court challenging the impugned order, my lords, which is in the page number 9, my lords. Trial court has passed the orders for maintenance of 15,000 rupees per month and 40,000 rupees towards the litigation expenses. In this regard, my lords, I have been before this honorable court challenging in the grounds that my father is suffering from the cancer and my mother.
What is your salary?
My lords, on 52 to 56,000 rupees per month, my lords.
50?
2 to 56,000 rupees per month after deductions.
What the wife is doing?
My lords, as per the earlier before marriage, she was working in one of the company. But later part after the marriage, she got resigned. And later part now, my lords.
Come to the order.
Yes, my lords.
Come to paragraph number 11. Paragraph number 10.
Yes, ma'am. From going through the pleadings of both the parties, it is clear the petitioner is a BSc degree holder. Prior to the marriage, she was working and earning. It is specific case of the petitioner. Now she has no source of income and unable to work as she went to depression. It is also not in dispute that the respondent is working as a staff correspondence with the editors Prajavani in measures of printer so and so. Both the petitioner and the respondent have filed their affidavit on assets and liabilities. In this regard, my lords, along with the assets and liabilities, the petitioner or the respondent before this honorable court had not attached any of the documents to prove. As per the affidavit of the petitioner, she claims that the respondent has monthly income of rupees 1 lakh, but the respondent in his affidavit has mentioned that he is getting home take salary of approximately 56,000. Along with affidavit, both the sides have produced the bank statement and other related. The learned counsel advocate for the respondent vehemently argued that the bank statement produced by the petitioner is not complete. She has not provided the bank statement from so and so. Therefore, she might be directed to produce either the original bank passbook or complete statement. Relying on the documents produced by the petitioner, learned advocate for the respondent vehemently argued that with respect to the medical bills to the Manipal hospital produced by the petitioner, mode of the payment is shown as a Phone Pay or Google Pay. From the counter checking the dates of those bills, the payments cannot be find any entry in the copy of the passbook produced by the petitioner. Therefore, he sought for a direction the petitioner to produce her complete account statement. From going through the copy of the passbook produced by the petitioner, it is clear that she has produced the Xerox copy of the passbook processed by her. From careful going through the entire each page, it is clear that it is a full document. Has from one page to the second page, we can find the documents has brought forward. Even though there are periodical gaps of 3 to 6 months, there are no entries from which it can be said that it not become complete document. As there was a transactions, there are no entries, but the amount shown in the earlier page tallies with the brought forward amount. Therefore, it cannot be said that the copy of the bank passbook produced by the petitioner is incomplete. With reference to the Phone Pay and Google Pay amounts, with reference to the medical bills paid towards the petitioner's hospital
What do you
charges.
say?
Yes, my lord. Now, the respondent is suffering from brain issues and also and other ailments, my lord. She already undergone operation and also. See, whatever the contention taken by the petition is that she is nowhere they have taken contention. She is earning lady. Now he is getting more than 70,000 per month as a salary. Apart from that, he is having agricultural property in Kathnalli, Pandopura Taluk, and also his father also having so many residential building at Vijayanagara Bank. Now he is a giant family. He is earning so much of amount, and his bank account reflects that he has maintained 11 lakhs rupees as a saving account. Now he is having a sufficient income to maintain the wife. Now the wife filed the petition on the ground of cruelty and desertion. He has not made any effort to take back from 2013 to 2024 itself. Now whatever the amount ordered by the trial court, considering all the materials, now the 15,000 is capable to pay the said amount. And also matter in the year 2018.
Which code it is?
The principal family code.
Yes.
My lords, in this regard, my lords, my contention before this honorable court, as per the document which is being produced by the petitioner before the trial court is, my lords, we have been transferred several amounts with respect to the marriage expenses, whatever the amounts with respect. Those transactions are not being reflected in the passbook. So it clearly indicates that she is availing she is having the other bank accounts and she is capable of earning, and she is earning also. This is what my contentions before this honorable court in the trial court, the same thing. Now, my lord, they have been produced the bank statement which the amount does not reflects in this particular bank passbook which has been placed the hands, my lord. Hence, my lords, what my submission before this honorable court, my father is suffering from the cancer. For every month, I need to pay from around 25 to 30,000 rupees towards the dialysis, and my mother is an old age, and she is suffering from the sugar and other things, and she is also liable. I need to take care of my mother, and she is around 5 to 10,000 rupees per month. We have to take care of for her medical expenses.
What about the properties and other land?
My lord, my lords, ancestor properties, we don't, in my name, I don't have any single,
Parents are having, why should you support
my
them?
parents does not have any single agriculture land. If it is so, my lords, if my parent have,
Building, the houses are not there, any. the
my
building
father
that-
my father have the one house wherein they are residing over there. There is no rental income or any other incomes from that particular property. Only the residential building where my father and my mother
What was
resides.
your father?
My lord?
What is your father? What is it?
My father was practicing as a veterinary doctor privately, and now he is not working from past 15 years, my lord, due to the cancer.
Then now you have to support your parents. You also have to take care of your
Exactly,
wife.
my lord.
Then 15,000 is what granted.
My lord, the 15,000 which is been granted by the trial court is higher amount, my lord, because what, as per my salary which has been, I am earning is 52 to 50,000, 56,000 rupees
75,000.
after deductions, my lords. I have been produced the salary slips also before the trial court, and with respect to few months,
Then if you are not having anything, how there is 11 lakh balance in your account?
my lords, to that effect, my lords, I have been produced the document to show that I have been availed the loan also to my for the emergency treatment of my father. I have been regularly paying the EMI to the concerned HDFC bank. I have been produced the document also to that effect before the trial. It has been illustrated in the impugned order, my lords.
Yes.
Kindly look into the.
Where are the medical documents to show that
Here
she's
we have
suffering
placed,
with?
we have placed in us along with assets and liabilities affidavit before the trial court.
Yes.
I'll
Take that.
She is under medication also.
Page number 6.
Brain issues and also other
Page
ailments,
number
my
14, my lords. In page number 14, my lords, page number 6. I am regularly paying the 10,800 rupees as a EMI to the HDFC bank, my lord. In this regard, my lord, that in the year 2013, the respondent left the petitioner and she has been deserted from the house. She has came back. In the year 2018, after lapse of 5 years, my lord, she has filed the petition before the trial court for the under the cruelty and desertion grounds for the divorce, my lord. And the trial court, the petitioner, the respondent herself has been approached the court for the divorce, and the trial, they have been sought for the litigation expenses. And in that regard, my lord, the trial court has granted the 40,000 rupees as a litigation expenses. After lapse of 5 years, my lord.
According to you, how much should be the maintenance?
My lords.
According to you, how much should be the
My lord,
maintenance?
as per the orders by some of the interim orders, my lord, the 10,000 is been granted, my lord. At least some less may be granted, my lord. 7 to 8,000 rupees, I may be permitted to pay. I am regularly paying the maintenance also to that.
Yes.
And the litigation expenses, whatever the order, if the orders passed by this honorable court, my lord, the trial court is not.
Yes, still filing up the application.
The court has been, this honorable court has been stayed the orders which has been with respect
Still
to the
filing up the application before the trial court. He has maintained from 46 lakhs to 11 lakhs from periodical. 46 lakhs. From 2022, he received 46 lakhs. Now he has maintained the 48 lakhs from in his account. And also again, he maintained 11 lakhs. Now after the filing the application, he reduced all the amount in his account to show that he is having so much of expenses. Now then come to 11 lakhs to 77,000 he comes. Now it shows the conduct because of hiding the income and also other things. He has filed the. Is capable to maintain it.
My father has undergone 3 operations, my lords. We have been spent huge amount for the treatment. I've been taken the loan also to that effect.
Please come. Agree with orders passed in I number 4. in MC number 3678 of 2018 dated 3rd June 2024, whereby the court had granted an amount of rupees 15,000 per month to the wife and 40,000 the litigation expenses. The husband is before this court. By way of an expert, this court, by way of an interim order, had directed the husband to pay an amount of rupees 10,000 per month. Arrears also at 10,000.
I have been paid, my lord.
Arrears also.
Yes, yes.
At
Up to
10,000.
date, we have been paid, my lord.
At
No
10,000
arrears.
At 10,000.
Yes, yes, yes. Arrears, the Dismissal court has been specifically advised that per month 10,000 rupees. It was arrears was 2 lakhs. We have been paid by way of DD and
The 10,000 per month and also 10,000 towards arrears. Then counsel for the petitioner submits that from the date of order, they've been continuously paying. There are no arrears as of now. It is submitted that the take-home salary.
One submission, the litigation expenses not being paid.
yes.
And the court had granted stay on the litigation expenses. Then counsel for the petitioner submits that the parent, that the father is suffering from illness and he has undergone 2 surgeries.
Three operations.
Surgeries. It is a case that his take-home salary is 56,000. He has to take care of his parents, and particularly the father, who is suffering with ailment, and also take care of himself. It is submitted that the court, without considering all this, had granted an amount of rupees 15,000 as maintenance. It is submitted that the wife is capable of earning, and she has not disclosed anything before the court. The court ought not to have granted such an amount, exorbitant amount, as maintenance and towards the litigation charges. It is submitted that, considering the health condition and the requirement of the money, we have taken loan from the HDFC Bank, an amount of rupees 11 lakhs for the requirements of the parents, and he is paying EMI towards that loan. It is submitted that the amount may be reduced to 7,000. Next, when counsel appearing for the respondent respondent wife submits that earlier he was maintaining 48 lakh rupees as in his account. There was an amount of rupees 48 lakhs, and slowly it has come down, considering considering the application that is filed by the wife. It is submitted that, in fact, it's a husband who has deserted the husband, and right from 2013, he has failed to take care of the wife. It is submitted that apart from the landed property, apart from the income that he is getting, from the salary, the petitioner is also having other landed properties. It is submitted that the husband is capable of earning, and the court ought to have, and the court had rightly granted the maintenance. Next part. This court has perused heard the counsels on either side and perused the material on record. The husband's salary, take-home salary, is 56,000. It is, he has to take care of his parents and also himself, and he is suffering with ailments. This is a repetition of 2024, and from 2024, in the light of the stay granted with this court, he is granting an amount. He is paying an amount of rupees 20,000, paying 10,000, and as far as the litigation expenses of 40,000 are concerned, court has granted the stay, considering the fact that this is an MC of 2018. and as he's paying 10,000 from the last or more than a year, this court is inclined to make the said order absolute and also grant 20,000 as litigation expenses. As far as the MC is concerned, as it's an MC of 2018, the family court is directed to dispose of the MC within a period of by December 15th, and the party shall not seek unnecessary adjournments.
My lord, sir, litigation expenses may be reduced, my lord.
20,000.
Yes, my lord, little bit, it may be reduced, my lord.
Yes, next.
Till number 76.
Yes, 76.
76 urgent, 77. 76 urgent, 77. Vijay AM for petitioner, Amit.
For the respondent, my lord. There's a petition filed by the petitioner. Since the application for maintenance was dismissed since application was filed for interim maintenance in a GNW.
Counsel for the respondent is present, no representation for the petitioner. This is matter for dismissal on 29th.
Till number 78.
For respondent, my lords.
Yes.
My lords, I think the petition has become infructuous in view of the fact that the petition before the trial court has been disposed of, my lords.
What was it?
They have challenged the interim maintenance, my lord.
No, what is the MC disposed of?
That is the miscellaneous MC petition, my lord, for restitution of conjugal rights. In that they had made an application.
When was it disposed of?
8/6, my lords. 6th of, 5th of June.
This year?
This year, my lords.
It is submitted that the main MC itself is disposed of on 5th June 2025. As this petition is filed, learn counsel the respondent submits that disposed of. As this petition is filed, questioning an interim order in the MC, nothing survives from consideration in this petition. Accordingly, dismissed as infructuous. Next, 79.
79. Achal Anand.
For the respondent. Husband's writ petition. It's against the final order passed under section 125 CRPC.
How can he file a petition?
That's what office had not raised the objections. But anyhow, somehow it has come and we have taken notice also. I am now given to understand, my lords.
You can from
19(4) of the family code.
You can do it.
Pardon, my lords? No.
Oh, you can file a RPFC now.
We can, we have to
convert it. Yes.
Your lordship may permit us to convert it.
The petition, the writ petition is filed against the final order passed by the family court under 125 CRPC, and in the light of section 19(4) of the family court act, the present writ petition is not maintainable. Petition is permitted to convert this into a RPFC within a period of 1 week from the date of receipt of the copy of the order, and the office is directed to return the entire record.
Grateful, minutes.
May I make one submission?
Yes.
My lords, we have filed an RPFC arising out of the same judgment. My lords, it was listed yesterday, and notice is issued. My lords, it may be connected with this converted.
No, first of all, they have to convert. Then once it comes, we can correct it then.
Once it comes, we will get it.
Till number 80.
No issue.
Yes.
Till number 80. Rakesh. Ramesh HP.
May I please? Your lordship referred the matter to the mediation. This mediation is failed. Now what they challenge is, what the wife challenge is, the order passed by the Lok Adalat. Your lordship.
The counsel for the petitioner. Counsel for the respondent is present. No representation for the petitioner. This is matter for dismissal on 29th.
Till number 81.
I'm for the petitioner in this matter, my lord.
Yes.
The respondent has filed an application under section 125 subclass 3 of the CRPC for enforcement of an order. In that proceedings, the Honorable Trial Court passed an order directing the passport authority to impound his passport, which is not permissible under law. Your lordship kindly turn to impugned order.
Page number?
Page number 31, my lord. Typed copy of the order sheet.
He did not appear in the execution.
1 minute.
Coercive steps were
But
taken.
but the court, what are the powers of the court?
Brought the FLW was issued, and in the 125 proceedings, order was not challenged.
I can
He
understand. Let us take it that all orders are violated. But there is a procedure to enforce the orders.
No,
but
the
not by
locus
impounding the
standi, not
passport.
he would, at least he would have appeared before the execution
That is
court.
a different, now that we will ask him why he is not appearing.
Yes.
But that order is bad. Court cannot pass such an order. No, without
He's sitting in
appearing.
abroad
1
and
minute.
seeking a relief.
Without appearing before the court, without prosecuting the. Now, how you are before this court saying questioning the jurisdiction of the court?
Now, your lordship, kindly see the interim order. I voluntarily submitted it before this honorable court, and I undertake to pay a sum of 2,30,000 and obtain the DD. But the last date of hearing, the respondents were not present. The DD has been lapsed. Day after tomorrow itself, I will pay that amount.
Lord, the arrears.
And here in the case,
memo
he
calculation.
is in Dubai.
Take that memo.
Memo of calculation.
Your lordship, kindly see, he is in Dubai. Now he is finding very difficult to renew his passport because of this order. No, he cannot come down to India, my lord.
No.
That is a problem. Now he is working in Dubai.
Where is the calculation?
First page, my lord, the order has passed. It was not under challenge. The order passed it at page number 3.
2,30,000.
Yes, but that was the execution we filed.
Total amount is 7,10,000.
10,000 as on today. Did not pay single rupees.
I will settle the matter. I don't have any problem. But the problem is, because of this order, the passport cannot be renewed.
Why the order is passed? Because you are not appearing.
Yeah, but
you are not appearing.
This order is without any jurisdiction.
That's a different aspect. A
Yes,
person who is
without
at
any
fault,
jurisdiction.
the person who is at fault cannot come to the court and say that some order passed by the court is wrong. First of all, you have to set the
That's
things
why.
right.
Now, voluntarily, last date of hearing,
It is not
I
any
made the
helper.
submission.
It is
I will
not
pay
any
the
helper.
arrears. But
not any
here is the
helper.
thing. Now he is in Dubai.
Let him be.
Dubai.
Let him be.
Now,
Dubai.
because of this order, your lordship kindly see, because of this order, he cannot come down to India to
for
settle the matter. To settle the matter.
You made the court to go to that extent.
Not like that.
Yes.
No, we are not on the point whether the court has jurisdiction or not. I am on the point, a person who has violated the orders of the court, can he come to the court again and say, seek relief from the
And I
court?
could not locate that your lordship kindly see.
Now, when is the order passed in criminal miscellaneous?
That is in
Criminal
the
miscellaneous, please wait.
2019.
16th November 2019 is the order. You have not questioned that order.
Yes.
That order has become final.
Yes,
You
ma'am.
do not pay the maintenance.
I
You
will
don't-
pay the maintenance. I will pay the arrears. That is no.
You have to
that's
pay
no
the entire
problem.
amount.
But
Then
here in the
only-
thing, here in the issue, I will pay the arrears.
When will you pay?
But I want to. He has filed the
Calculation.
calculation. I will check it and I will.
Please check it.
But
Then-
here in the case, your lordship kindly see, on the last date of hearing, pursuant to the interim order passed by this on court, I have obtained the DD.
I know.
That
but,
the DD has been lapsed.
the-
After tomorrow itself,
the land council
I will
for
pay
the-
that amount.
Land
2,30,000.
counsel for the respondent has filed a calculation memo before this court. Land counsel submits that the court has no jurisdiction to pass an impugned order whereby the passport, there was a, what is that?
Impounding of passport.
To impound the passport. When an order is passed on 16 November 2019, directing the petitioner to pay the maintenance, when he has failed to pay the maintenance, the respondent wife has filed the execution proceedings. In the execution proceedings, when the petitioner has failed to appear,
Calculation.
the court has issued has passed the order impugnated 8/11/2021. When an order is passed in 2019, when the petitioner has failed to question it, is bound to pay the maintenance. In that view of the matter, as the respondent has already filed the calculation memo with regard to the said amounts, when is he going to pay?
And this, I will revalidate the DD. Pursuant
Not
to
only
the
that
interim order
amount,
by
there
this
is
court,
lot
after
of-
tomorrow I will pay this amount. 2,30,000.
7 lakh.
Pursuant to the interim order passed by this on court, I obtained the
No,
DD.
they are taken
The
undertaking.
DD has been lapsed. and I will revalidate it, and
Now
day
we
after
are on
tomorrow
the,
itself I
now
will
it is,
transfer the amount.
now it is not no more in the,
Electronical.
no, it is no more in the interlocutory stage. We are hearing the matter finally, because the respondent is here. So you have to finally tell the court, what is it going to be? How are you going to pay the money? And how do you undertake to appear before the court?
That I will pay. The issue in this matter, your lordship kindly see, this order is without any jurisdiction.
I understood.
Yeah, without any jurisdiction, how can the trial court?
I understood.
I will settle the matter. I don't have any issue at all.
I understood the matter.
Because of this order, their passport cannot be renewed. That's the ground reality. Your lordship kindly.
The same pain the respondent would feel when the maintenance is not
I
paid.
will pay the maintenance. That is not the issue. Here in the case,
pay the
this
maintenance.
impugned order is
Matter on which date?
Next week, my lord.
Yes, list the matter on 30th. By the time there should be clear instruction before this court when and how the amounts are going to be paid. Basing on that, further orders will be passed.
Yes.
Yes.
Next date may be given, my lord.
Next week.
29th. 29th.
24th.
29th is okay.
You can, 24th is also fine for you? 24th.
24th, 29th is okay, my lord.
29th. Yes, next.
Much obey.
Huh? Where is the passed over matter?
38.
Where is the counsel? Yes. Yes.
Not this. Here it is not the marriage in the year 1990.
We are not on any other factual aspects. Please come to your section 5 petition and the affidavit that is filed.
Lord, the order was passed in the year 2022.
Read your affidavit.
Yes.
No arguments on this.
I have made efforts to pay the maintenance to the child.
Mr. Counsel, please read your affidavit. I am only concerned with the section 5 petition, whether there are grounds to condone the delay. If there are grounds, then we will go into any other aspect. Please read that. Please read the entire.
Please.
It's a very short affidavit. Please read the entire affidavit.
I am the petition, para 3 onwards. The fact that the respondent herein has filed an application for 125 before the trial court for maintenance, wherein the mother of the respondent obtained a decree of divorce on 29/10/2013 in MC number 92/13. In the said decree, it has observed that petitioner is entitled for visitation a right to see the child once in a month for an hour. It is stated after obtaining the decree, the mother of the child has been shifted to abroad and married again and started to lead her family life at Goa without providing any visitation to the petitioner till today. And petitioner had approached the court seeking custody in WC so and so, and same was dismissed and appeal was filed before this honorable court as same pending with consideration MFA number 546/2020. I state that the respondent mother filed an application seeking maintenance to the child without complying the condition imposed in the decree of divorce, and same was allowed without considering the fact and passed an order in which it is very higher side. Further, the respondent filed a petition to execution 38/22. In the said procedure, petitioner has paid 2,41,000. It is stated that I am unable to mobilize such huge amount on every month. Hence, I am constrained to file present petition without any remedy at this stage. I had tried to comply the conditions imposed by the trial court, conditions paying the maintenance of 8,000 per month and rupees 2,41,000.
Is it the ground for section? Are there grounds?
For further, because of the financial difficulty, Lord, I am unable to challenge the order immediately, and for well-being of the child, I tried to mobilize the fund. In spite of my all effort, I could not pay the entire amount passed by the trial court, which is very much higher.
Please come. The present RPFC is filed.
But I'll file better. Only thing is, Lord, still today I have not seen my child.
Agreed with the orders. Lord, the present RPFC is filed.
Lord, one submission. He is a carpenter. He is mobilized. I'll see the order sheet. Not from the date of order, he is paying 5,000 rupees. There are some areas, Lord. He had tried his all efforts to pay the maintenance to the child and visitation right. She don't have any respect to the court order. She is not allowing to see my child.
Agreed with the orders passed in criminal
I
miscellaneous.
pass on the order sheet also, my lord, in support of my application.
Criminal miscellaneous case number 26 of 2017.
And wife is not
Dated
giving any
23rd
respect to
November
the order of the
2021.
court.
The RPFC is filed. The RPFC is filed with a delay of 568
days.
how many?
568 days.
568 days, along for the under section 5 of the Limitation Act. An affidavit is filed. It is stated that the respondent herein had filed an application under section 125 of CRPC before the trial court for maintenance, wherein the mother of the respondent obtained a decree of divorce on 29/10/2013 in MC number 92 of 2013, and in the said decree it is observed that the petition is entitled to visitation right to see the child once in a month for an hour. After obtaining the decree, the mother of the child had shifted to abroad and married again and started to lead her family life at Goa without providing any visitation to the petitioner till today. And petitioner had approached the court seeking custody in GNWC number 10 of 2015, and the same was dismissed. Appeal was filed before the court, and the same is pending for consideration in MFA number 546 of 2020. It is also stated that the respondent's mother filed application without complying the condition imposed in decree of divorce seeking maintenance, and the same was allowed without what did you write? No. GNWC, and the same is pending for consideration in MFA number 546 of 2020. The respondent's mother filed application seeking maintenance to the child without complying the condition imposed in decree of divorce, and the same was allowed without considering these facts and passed such order, which is very much higher sided. Full stop. Further, the respondent filed a petition for execution in criminal miscellaneous number 38 of 2022, and in the said proceedings, the petitioner had paid rupees 2,41,000. It is stated that he is unable to mobilize such huge amount on every month. Hence, he is constrained to file present petition without any remedy at this stage. It is stated that he had tried to comply the condition imposed by the trial court by paying the maintenance at rupees 8,000 per month and rupees 2,41,000. Because of the financial difficulty, he is unable to challenge the order immediately, and for the well-being of the child, he had tried to mobilize the fund. In spite of all efforts, he could not pay the entire amount asked by the trial court, which is very much on the higher side. Hence, he filed the present petition. Then counsel appearing for the petitioner submits that the petitioner is not in a position to pay the amount, and for filing the case also, financially, he is not in a position. As such, he could not come to the court immediately. It is stated that the mother has failed to give visitation to the father, and when she has no respect to the orders of the court, she is not entitled for any relief. Next para. Then counsel appearing for the respondent has filed his objections to the petition, and it is stated that when an application is filed under section 5 of the Limitation Act, and that too after an inordinate delay of so and so days, the petitioner has to state the reason for such delay and the reason for the day for each and every day's delay has to be explained. It is submitted that the delay cannot be condoned. The delay cannot be condoned. Next, for having heard the counsels on either side, permits the material on record. This case is filed with a delay of 580 days. 580 days.
568.
568. 568 days. When with such inordinate delay, when an application is filed, and he has filed an application, when this petition is filed, and when an IA is filed seeking condonation of delay, the petitioner should have explained to the court why the delay has occurred. The reasons that are stated are: one, the wife is not providing visitation to the father. Number two, three reasons. Number two, he is not in a position to pay the amount, and is not able, and is not in a financial position to approach the court. Hence, there is delay. None of the reasons that are stated by the petitioner cannot be a ground to condone the delay. If a party, after 10 years of time, feels that he is not able to pay the amounts as per a judgment passed by the court, questioning an order that is passed long back on that ground it cannot be a reason for the court to condone the delay. Any of the reasons that are stated in the condonation petition are not convincing and cannot be the reasons for condoning the delay. Accordingly, the IA number so and so, point under section 5 of the Limitation Act, is dismissed.
Consequently,
Yes. Next. Oh, dismissed. Yes, next.
Cell number 82.
Huh.
Your lordships had suggested that the entire family go through therapy. So the respondent is amenable to it, both the child and her, provided that the petitioner also undergoes.
Yes, then if all of you are ready, what is the problem? Go. Go to the Nimhans. We'll pass an order. Huh?
Lords, the petitioner in that regard has to
Why the
undergo.
child? What happened to the child?
They are just, I don't think they should be making these
Yes.
statements. My lords, these
No,
are
that's not what your client has said the other day when he has come to the chamber. Is it a case where both of them are scientists?
Yes, my lords.
Yes. I have met that is not your client's case. Your client is finding fault with the wife. He never said that something is wrong with the child. He never said so. Court said like something is wrong with both the parents. First of all, to set right things, both of them have to go for whether with their upbringing, whether the future of the child is at is he safe or not is what is the question. The present writ petition is filed. Agreed with the orders passed in I number 2 in JNWC number 258 of 2024, dated 21st September 2024, whereby the court had granted visitation on first and third Saturday of every month from 2:30 p.m. to 5:30 p.m. in Children Visitation Room, Family Court, Bangalore. The father has come before this court, questioning the said order, stating that the boy is very much attached to the father, granting visitation between 2:30 to 5:30 p.m. in the visitation hall, in the visitation room of the family court, is not adequate for the father to develop the bonding with the child. And on the last occasion when the matter came up, both the senior counsels appearing on behalf of both the parties have argued extensively. It is submitted by the senior counsel for the petitioner, father, that the boy is very much attached to the father. Father is a scientist in DRDO.
Yeah.
Father is a scientist in DRDO, and the court ought to have granted the visitation outside the visitation room and should have been given should have granted adequate visitation to the father where both the father can take the child outside. Then a counsel appearing for the senior counsel appearing for the respondent mother has submitted that father behaves in a different way. Whenever he is angry, he inflicts the self-injury and he behaves in a weird manner. According to the senior counsel, the father's state of mind is not good, which is denied by the senior counsel appearing on behalf of the father. Then this court had directed the parties to be present before the court, and the court has, in the chambers, the court had interacted with the father, mother, and the child. The mother and father, mother is working as a scientist in ISRO. Mother is working as a scientist in ISRO, and father is working in DRDO. During the course of interaction, mother has stated so many things, and even looking at her, the court could understand that she is under tremendous stress, and she has narrated the events that had taken place during when they were together. When this court has interacted with the father had also had informed the court and also about his side of the story. But looking at both the parents, the court could understand that both of them, though medically or psychologically what it has to be stated, as this court has not the authority to say anything on that. But the court felt that both the parents require a psychological evaluation to find out exactly what is going on with both of them. Once that aspect is decided, and as well the boys are also evaluated, that would be in the interest of all in the interest of the parents as well as the child. Hence, this court is passing the following order. The three of them shall go to the Nimhans on go to Nimhans on 29th.
Please, Saturday, my lord. Saturdays.
On 2nd of August.
Please.
On 2nd of August.
Thursdays and Saturdays they will be.
Then Thursday also they'll be free.
She might have work, so it will be difficult. Saturday.
So what happens is Saturday the hospital will be busy. If Thursday is fine, you better go on Thursday.
May I seek instructions, my lords? I'll just ask the.
Just ask her and come back. Only that part. So and so on the day they shall go, and the court, and considering the doctors at Nimhans shall examine the three of them. If any further sessions are also required, they shall evaluate all the three and shall place a report before the court about their condition. Shall place a report before this court. You can tell that to the court officer. Only the date. Can inform him also. List the matter after the report is placed by the Nimhans. Yes. Now they will tell.
Sir,
They'll tell
83.
whether it is Saturday or Thursday, right?
Cell number 83, G.S. Venkat Subbarao, for petitioner.
Yes.
The respondent.
This is matter on 17/7, and by the time land counsel get instruction on when the wife is going to come to India, subjecting herself to the cross-examination.
Apple will not be submitted by the other side. If there was some exchange of mails between the parties, we have to. 3 days back, we have client received 1 mail, which she must have responded stating what could be that she is looking at the settlement is. So It would be heard from their side.
My lords, if I may place just the email so that it's easier for me to read out, my lords. My lords,
Take
first,
that.
my lords, first of all, what she's demanding is exorbitant. She's asking for 250,000. That comes up to about 2 CR per child. He is earning in India, he earns only 3 lakhs, whereas she is earning 18 to 20 lakhs. And moreover, the kids have, both the children have holidays, vacation till August 15th, my lords. So if she comes, if for her, property is the only concern. She is not interested for a reunion because in spite of us filing for a divorce under 13(1)(a), we still in the evidence said that if she is ready for a reunion, we would still like to consider that because of the 2 children. And both the children are attached to the father. But since the time of separation, she never allowed even on audio or video to speak to the father. Though he sends gifts and all that, sometimes she takes, sometimes she sends it back. So this was the issue. And as far as the divorce is concerned, my lord, let her go on with that. If she is interested to close the matter, she can come online and finish in the mediation center. But as far as the property matters are concerned, all the property documents are with her in the locker. Keys are with her. This is what was informed by my client, and even her father, when he was alive, he said the same. Now, for the property matter, she can always file another suit if she is interested, or he cannot sell the property at all because all the papers are with her. So, one is either she comes down because the kids are having vacation, or she has to settle the MC matter because it is 2000 matter. January 7th we filed, my lords.
When is that?
7/1/2019. And thrice they came back, though it was ordered for the next stage, thrice they came back saying that they will come for the evidence and so on. So 3 times it was recalled. It was recalled. Yes, my lords, 3 times they've paid the costs and they've recalled. And even on the last occasion, they said they will give a date when she'll come, but subsequently they
There is this
came up
MC.
with. Yes, my lord.
MC is 2019.
I didn't get it. ma'am.
MC is 2019. MC
Yes, 2019.
Oh.
7/1,
Which court is this?
2019. 6th additional family court.
We'll
my lords,
ask the
Bangalore.
court to dispose of this matter by December.
December, yes, ma'am.
I'm sorry, my lord. Whatever submissions that are made, my lord, there is no inclination in settlement. But they could
No, we
take a
have.
cost.
We are settling it, my lords.
But he files a petition for divorce and seeks reunion.
No,
Do not understand
because it is only because why he filed was she filed a domestic violence case in US. He was handcuffed and taken to prison. No, he was handcuffed and taken to prison. She is not interested in the reunion. No, that is a lie.
That's how, my lord, is the content.
His mother was very sick.
That is there on record.
Yes.
That is there on record.
Yes, mother had knee replacement.
Properties are there. Two, my lord. One is in the joint names. Another one, my lord, in the name of the petitioner. Another one in the respondent. But by instructions of my lord, it is being contributed by her, my lord, so far as acquisition is concerned. But she knows, my lord, that the documents are with, my lord, with the custody of the bank, my lord, it is there. She cannot come back to India, my lord, for this reason. But when all of them left together in India, but she went on a work visa, which is not extended. But the employer has provided a registration where the work permit is being extended and she is staying there. But she comes back here. She'll have to leave the children there, and come back. But if she cannot, by any chance, having regard to the present state of affairs and circumstances, visa does not get renewed. But she cannot get back to children who become orphans there. But one is 17 years, another one is a little younger. Therefore, that is the reason. The father was there, but he held the power of attorney. Several negotiations went through, and it was referred to mediation. Proper matter to transpire. After the death of the father, this is the situation she is faced. She is unable to submit, come down to India. Because under these circumstances, we moved an application that through the video conferencing facility, evidence would be recorded. Which please look at the order that the family court passes.
That's what I told you on the last occasion. This court has already passed order saying that it cannot be done.
I told him. Please look at how the order is passed. court will not want to have considered this.
My lords, may I make one submission, my lord?
Wait, madam.
His colleague, no, just this, because his colleague came. And when the court asked, how are you going to conduct this matter? He said, send it to mediation. So the judge said, the learned judge said, it can't be done in mediation. That is how the mediation came there. So it was his own submission, which he is turning it. He was not present also, my lords. His colleague spoke. I mean, he was there. Yes.
Side counsel, respondent side, appointing the court commissioner seeking recording of evidence of the respondent to video conference via mediation center. That is not our case. That's not the application. But the learned judge refers to an application. That is not what we have said in the application. The court commissioner is appointing the examining the witness, where actually the witness is decided. But here the respondent is saying, I'm not appointed to the court commissioner, examining the witness through video conference. There is no such procedure according to the rules and regulations by the court commissioner through these. In order to examine the witness, the court will these. There is no proper procedure. So the earlier finds that the respondent is recording of evidence in the mediation center, which was not a place by the court commissioner appointed by this court to mediate. Accordingly, the question is asked the following. Number 13 is rejected. Court at least upon receiving the application, after at least heard us, they would have said, what is happening now in the arbitration center? Where several other matters, the witnesses are deciding upon. There, the evidence is recorded from the process of video conference. That one attempt could have been made to the process of the court. Referring to it, that's why we sought for an appointment by the commissioner. The matter could be referred to the arbitration center where they have a facility to record. That could have been, that is a possibility that could have been explored. If the learned judge will not soon after receiving the application rejects it, that is what is because. Therefore, rules will not rehost the rules. Not having regard to the present facts and circumstances, court ought to have heard us in the first instance by the application must move, and there are 26 rule 13 the rule 4 under which the application will move. Clearly, postulates that the examination of the witness who decides outside the jurist or the union territory. These circumstances, the application ought to have been at least heard us before passing the order.
Heard in the sense, what is heard?
So that we could have placed before the court.
It's no. You ask the court. No, you ask the court to do it to have this examination or cross-examination via video conferencing. That's what. What else would be the other things?
Court refers to mediation center.
No, forget about mediation. Otherwise,
process could have been how it is done in arbitration center.
That will not be done. Family court will not go to the arbitration. A matter of the cross-examination and all will not be done from the arbitration center.
We are not seeking a reference to arbitration center.
Understood,
We are
sir.
seeking appointment of a commissioner only for the purpose of recording the evidence.
Yes.
But if the person witness is within the jurisdiction of the court. But amended 2002 CPC provides for the examination of a witness through the court commissioner. Therefore, similar LHG could have been applied for a resident person who is deciding outside the country. No, various notes that were available. So the mediation was not what was sought for.
Yes, yes. Please come. Huh? Saturday. Give the date. Tell her the date. Please come. That order. The Lakshita to get that order. The order passed by me with regard to this video conferencing rules and examining the witnesses who are abroad. That order is taken. The agreed with her. Where is the page number order?
Page 19.
19. agreed to the order passed by the family court in I number 13 in MC number 159 of 2019, dated 16/12/2024. The wife is before this court. Parties are referred to wife and husband for the purpose of convenience. The husband had filed MC number 159 of 2019 seeking divorce. At the time of the evidence, the wife had come up with this application under Order 26, Order 22, Rule 4, read with Rule 5, read with Order 18, Rule 4 of CPC, read with Rule 6 of the video conferencing in court rules, read with Section 151 of the Code of Civil Procedure. That application came to be dismissed by the court by order impugned, wherein the court has observed that the court commissioner is examining the witness where actually the witness is residing. But here the respondent side have sought appointing the court commissioner examining the witness through VC. There is no such procedure recording the evidence of the witness by the court commissioner through VC. In order to examine the witness in the court through VC, there is no proper facility. So the IA filed with the respondent seeking recording of evidence of the respondent through VC in the mediation center by the court commissioner appointed by this court cannot be entertained. Accordingly, dismiss the application. The land counsel appearing for the petitioner submits that nobody has asked the court to examine in the mediation, has asked for the court seeking recording of evidence through VC via mediation center. It is submitted that the wife is residing in the US along with the children, and her preoccupation with the work is not permitting her to come to India. It is stated that in several matters, when the evidence is recorded through VC, the court also ought to have permitted the wife to be examined, cross-examined through VC. If she has to come to India, she has to leave the children there, and it would not be, and it is not in the interest of the children. The court, without considering any of the possibilities, without assigning proper reasons, had dismissed the petition. Land counsel appearing for the respondent husband submits that the petition is filed in the year 2019 by the husband seeking divorce. Wife is not interested for reunion. In that case, the matter is pending from the, what did you write? A matter is pending from 2019. It is submitted that in several cases, the Honorable Apex Court has particularly in these kind of matters, had always insisted for the presence of the parties, as demeanor of the witness is very much important for the court to come to a just and reasonable conclusion. Next paragraph. Having heard the counsels on either side, there is the material on record. Before proceeding with the matter, it is appropriate to look at the IA that is filed. The IA that is filed is for order of appointment of a court commissioner as deemed appropriate in the facts and circumstances for recording of evidence of the applicant respondent through video conference who is presently residing out of Union Territory of India. In the memorandum of facts, it is stated that that the wife has two minor sons born in the wedlock. And she is residing along with them in the US. The children who are tender age are pursuing their education in United States of America. And she is also permanently residing in America on account of her employment. Earlier, she had appointed her father as her agent and power of attorney holder to attend the petition for and on her behalf, and he was contesting the matter. Her father died on 2/8/2023, and ever since she is providing oral instructions to conduct the case. It is stated that there are no other persons in Bangalore. Hence, the evidence has to be recorded by appointing a court commissioner through video conference, and therefore the present application is filed. And if the respondent is not permitted to adduce evidence to video conferencing, she would be put to greater hardship, loss and inconvenience, and on the other hand, no hardship would be caused to the other side. First, the submission of the learned counsel. First, the application that is filed is appointing a court commissioner to record the evidence virtually. The trial court had rightly considered this aspect and rightly held that there is no such provision for appointing an advocate commissioner to record the evidence through video conferencing video conferencing. The state of the video conferencing rules during the COVID time were framed. This court earlier had an occasion to go through those rules and how practically in these family cases and in the high contested matters, how those rules are not able to be implemented. This court has passed an elaborate order, and those rules were made during the COVID time. Unless and until the rules are amended, it is practically not possible to implement them. When the parties are residing outside the country, somebody from the consulate shall be present while recording the evidence. This court has observed that is practically not possible, that each and every case, if the consulate, any member from the consulate office has to be present for the said video recording, for the said evidence. And that apart, as in evidence, the demeanor of the witness is very much important. And in fact, when the matter came up on the last occasion, this court has specifically asked when will it be convenient for the wife to come back. It is submitted that she is, because of her job, she cannot come. If she come, the children will be they will be alone. What is the age?
17 and going to be 17 this December. The other child is 14.
The children are 14 and 16, and it's difficult for them. When the case is filed by the husband in 2019, forever we cannot wait for the wife. The wife has to come before the court and complete her evidence, and she cannot say that even for the short time she cannot come. And as this is the court has rightly recorded the findings, and this court that court has also recorded that the VC facility is not proper in the court, and the court has not recorded about the video conferencing rules, and even on that count also, this application cannot be considered. In that view of the matter, this court do not find any reasons to interfere with the well-considered order passed by the family court. This matter is pending before the principal. Which court it is pending?
6th additional.
Before it's pending before the 6th additional judge, family court.
Bangalore.
This court has already issued directions to the family courts to dispose of the matters till 2019 by December 15th. Hence, the court shall expeditiously decide the MC.
My lords, till 15 their vacation.
On instructions, it is submitted. Yes, on instructions, it is submitted. Yes.
84, 85 urgent, 86 urgent, sale number 87. 87.
Okay, for respondent, Millard. Millard, list this matter tomorrow. List this matter for
Why?
tomorrow. Senior is out of session.
What is the order?
ಡೆತ್ ಆಗಿದ್ದಾರೆ ಈಗ ಜಸ್ಟ್
How much is granted?
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ರೆಡಿ ಇದೆ ಮಿಲಾಡ್.
Tomorrow?
Tomorrow.
Listen. So when do you want? Monday. This is matter.
Sale number 88. Ramachandra Halli.
Yes.
Tota.
Dismissal of the maintenance application made by the husband. There is no ground urged in the trial court. Okay.
That is his petition. Let him argue. Yes. Where is the order? What is an app? Keep along with that. What is an application filed under 25 or 24? Filed by the petitioner under section 24 of the Hindu Marriage Act is hereby rejected. Come to paragraph number 22. 22. Paragraph number. Please read that. No, the daughters are staying with the husband. Huh? You are for the wife. When you saying dismissed,
Both of us filed the application under section 24. Both applications had been dismissed.
oh, no, this husband has filed an application to section.
Yes, yes. He is challenging the dismissal. My application is dismissed on the ground of, I have filed the application in the year of 2020. I have pressed the application in the 25, only on the ground that my application is dismissed.
No, what is the income of the wife? Hmm?
Mediation center. The petitioner responded mother. Actually, requested. We are ready to give two sides. Sorry, Anumala. It's better fix the matter and give the use. Of course, subsequently, the EC came out and once. Then later on, this is the situation.
Use the mic.
Dispute regarding welfare of the children. Court has to do what are the requirement court has to do.
We will not do all that in a petition for divorce. In a petition for maintenance, we will not look into children welfare and all.
Yes. Question is
It is not for the children, it is for the husband.
on the contrary, as of now, he don't.
No, Mr. Counsel, please tell the court what is the income of the wife, what is the evidence?
Evidence is what you are asking. Heard to the my feeling. Page number 7. When it goes on process,
Page number?
7. My plea. ಈಗ ನೀವು ನೌಕರಿ ಮಾಡ್ತಿರೋದ್ರಿಂದ ಮಕ್ಕಳ ಭವಿಷ್ಯ ನಿಮಗೆ ಸಹಕಾರ ಮತ್ತು ಸಾವು ಮಾಡಿ ಒಂದೇ ಇರುವುದಾಗಿ ಅವಶ್ಯಕತೆ ಇದೆ. If you try the aspect, the children will have happiness. That is the question. Then we get ನನಗೆ ಕೆಲಸ ಹೋಗಲಿಕ್ಕೆ ಆಗುವುದಿಲ್ಲ. ಅದರ ಬದಲು ನನಗೆ ಇಷ್ಟವಿಲ್ಲ. These are so important. Then second one, ಎರಡು ಮಕ್ಕಳು ನಿಮ್ಮ ಜೊತೆಗೆ ಬರಲು ತಯಾರಿದ್ದಾರೆ. The two children are ready to join. ಗೊತ್ತಿಲ್ಲ.
I asked you one simple question. What is the income of the wife? That's what I asked.
That's what I mean. The indulgence of the group is required. You have given.
Come on, I'm not able to hear what he's saying. It's not clear at all.
Ascertain the facts. Ascertain the facts, circumstances regarding, that's what I wanted to relay the Bombay court judgment. There, the court has ruled, for a moment I will read out there. A provision is made under the rules framed under Family Court Act to seek assistance from the marriage counselor.
Madam ಕೇಳ್ತಾ ಇರೋದು ನಿಮ್ಮ wife ಗೆ ಏನ್ source ಇದೆ ಅಂತ.
ಅದಕ್ಕೆ for that purpose only I am drawing this attention because
Law is different, facts are different. I am on facts. I want to know
yes,
what is the income of the wife and how on what basis husband is seeking maintenance.
in fact, my lord, Even she's working in the somewhere, in his examination, the Cunningham Road. That is a company under the physically handicapped, but she denied that. That is in fact, I could not trace out. She is also highly qualified, it is not in dispute. In addition to the conduct has to be taken into consideration, she has withdrawn the maintenance petition. She doesn't want any, but she is interested only to divorce. And again, she doesn't want to take the responsibility of it. I'm also saying, even he has got a residency also. But now she's there.
Do the judgment. Do the judgment. Which para you are relying on? Please tell the court. Which para?
May I kindly
Did not
see
be
their
para-
application
did not-
at the page 42.
1 minute.
Did not para. Bombay court.
Not head note. Where is it discussed?
ಸರ್ ಫ್ಯಾಕ್ಚುಲಿ ನೀವು ಎಲ್ಲಿ ಹೇಳಿದಿರಿ ಇಂಥ ಕಡೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ?
No, look, I said that, but in the cross I also asked, she denied. That's why I'm not disputing it.
If you are not disputing it, how are you entitled for maintenance?
No, at least some effort would have been made by the court regarding that is the main reason I am seeking indulgence of this court. At least all the parents, for a moment, in order to safeguard the interest of the children, I'm saying, all the parents, indulgence of the court is quite necessary in such a situation. Then, if anything, because you have also given an example, even I gone to the extent of saying that even if you look after children, I am ready to give a divorce. Only the question of your lordship, I don't want to explain what are the problem faced by the female kids. Both of the, and one of the kid is suffering from illness or some, this is their second child. And he is, as of now, he is jobless. And only his father, who was a retired military officer, through his income, only entire family is studying. In addition to that, one of the daughter of his father.
Why is the staying with the father, but not with you?
Because he's having illicit relationship with the respondent number 2.
No, I'm asking about children. Why the children are not with you? You are the mother, isn't it?
Earlier children.
Please wait. Why are you not taking care of the children?
Since there is a serious dispute between me and they.
What the children did? You have a dispute with children also?
No.
Then why are you not taking care of the children? When anybody leaves?
Since I'm a disabled lady, I could not able to look after the.
What is the age of the children?
Children
14 and 12. 14 and 12 minutes. As of now, 15 now.
How long they are with the father? From how long they are with the father?
From 2018.
Till they are getting married.
Till they'll get married, they'll be with the father. Mother has no responsibility. She doesn't even look after them. It's very strange. And why you want divorce? Because for everything, disability does not, disqualify you from marrying. Disability doesn't disqualify you from marrying. Disability doesn't disqualify you from having children, but it only disqualifies you from taking care of the children.
Serious health.
What is the serious health condition?
She's in a handicapped.
So she never, you never even see the children. They never come to you, never go to them.
It is there is a relationship between mother and daughters. Both are daughters. There is a intimacy between the mother and children. There is no dispute. It is only dispute with the husband. He is having some illegal relationship. Wherefore, I seek the divorce.
You seek the divorce, but you don't want the children. Is it clear?
My claim is not that I don't want my children, but
you don't want.
Since I am not having any source of income, I could not able to provide the education to the children. Wherefore, I am living with him for their educational purpose.
If he pays the educational expenses, you will take care of the children.
Definitely.
Yes, even I questioned also. I am ready to contribute. But house is there, a flat is there. He is ready to give that flat to the children. That he has stated in his examination chief also.
Here is the challenge is for the.
That we understand what is the challenge here. But what is, why there can't be any end to all this?
I'm ready to take care of my children if he maintains.
That's what he's saying, he's ready. He's giving that. Have you, was it discussed between the parties? What is your client's take on that?
I will ask my.
When counsel for the petitioner submits that he is ready to give.
But divorce. No, I was no, a flat,
Where?
a flat somewhere Anekal or something like that.
Is ready to give a flat for a full and final settlement, and the counsel for the respondent submits that he would get instructions in this regard. This is matter when?
Monday.
Not Monday. This is a matter on 24th.
Okay. 18th and 25th.
Huh?
25th.
24th I'm saying.
25th.
25th.
Bill number 89.
In this case, I
89.
agree for the petitioner. The petitioner has challenged the order asked by the trial court on maintenance application filed by the respondent under section 24 of the Hindu Marriage Act.
Why it is adjourned on the last occasion?
Pardon, my lord?
It is adjourned on the last occasion, if I remember.
Yes, ma'am.
I asked you a question. What is
Yes,
that?
my lord. To show the income of the wife. I am producing the.
Was it produced before the trial
court?
court? That I asked.
Pardon, my lord?
Was it produced before the trial court?
Yes, my lord. Yeah, it has been produced before the court, before trial court, and it has not been looked into by the trial court.
Pass on that.
Yes, ma'am.
What is the income of the husband?
25,000. I have produced the salary certificate.
25,000.
25,000, 587, 857. I have produced it, annexure G and H, my lord. She's become graduate. He is only an SSLC person. And
so what is her income?
Her income is actually 20,000. She is working in school, but she has shown us 10,000.
Where is the document?
Pardon, Mela?
It is not you stating. There should be a document for that.
Document. She has filed the asset and the liability.
This is her statement of assets and liability.
Yes, Mela.
Chaitra.
It is at page number 17, my lord.
Ongoing or past legal
40th.
Dependent. It's incurred on account of the dependent, 1,20,000. It was food. Name of the details of income of the deponent. Kanva Public School, for the East West Institution, Dharansh Palyan. Monthly income is 10,000. And no, the 10,000, and both the wife and the daughter has to live on that.
12,000. The impugned order. The operative.
No, that is both to the daughter and the mother.
Both. 12,000. It has been stated.
What is the age of the daughter?
Now she is 7 years old, madam.
What would be her school expenses?
She is studying in school expenses. She has given exorbitant rate, but it is not so, my lord.
Even let's take minimal. How much it would be?
It will be about 5,000
per month.
Yes, ma'am.
So 5,000 per month. Yes. Then what about her? Apart from her school expenses, there are other expenses. She has to eat. She has to do that and this.
She is well off, my lord. She is well off when compared to husband. Husband has to
forget about her. Completely forget about her. Forget about the wife. You talk about the child and your contribution for the child. 5,000 towards the school fees. Then there would be some other expenses.
There will not be 5,000 also. Everything, including everything, it will be 5,000.
For an year, less than 60,000. What kind of school you will get? Minimum 60,000 fees will be there in any school. 5,000 to minimum. So 5,000 other expenses.
No, taking into account the position of the parties, my lord.
We are not taking into 10,000. Even according to you, we'll take what you say. 10,000 is a wife's salary. 25,000 is the husband's salary.
Yes, my lord. Husband has to take care of his aged parents. That I have produced.
He will also have her parents. She will also then if he has to take care of his parents and not to take care of others, Why was
No,
he
my
having a
lord.
baby?
I have produced the medical certificate showing that his father has
Where is the
undergone
other side?
spinal cord operation
For
also, my lord.
representation for the respondent. Stay is granted.
Yes,
Stay is
no,
granted.
no, my
There
lord.
shall be stay
I'm
of all
seeking
further
for stay of
proceedings
the order.
on the condition that the petition shall continue to pay an amount of rupees 9,000 per month.
No.
Arrears also at 9,000 and by 5th of every
One
succeeding month.
submission, my lord. It
Arrears
may be made 7,000, my lord. Because he is getting only 25,000. He is residing in village, my lord. He is not having permanent.
If he is residing
salary.
at village, all the more reason the expenses
No,
are
no.
less.
He is he is in a village and his job is not a permanent job. Your lordship may kindly look into the annexure. which has
7,000 and arrears also, arrears within 4 weeks. Yes.
Till number 90, judgments, last check.
And litigation expense may be waived off, my lord.
And how much is given?
10,000. 5,000 Madison.
Not now, we'll say later. Yes.
Appear for the petitioner.
Respondent in this
Husband's
matter.
petition.
Huh?
Husband's petition,
Oh.
madam. Section 125(1) application.
Hmm.
Interim maintenance of rupees 30,000 to the wife and 20,000 to the child is ordered, my lords. The
How much
wife,
is, how much it is?
30,000 to the wife and 20,000 to the child, my lords. Child is aged about 4 years. My lords.
Child is 4 years.
4 years. Husband has filed a divorce petition, my lords, that they are contesting, my lords. Wife is working as an assistant professor in a Jain University, my lords. According to her assets and liabilities also, she is earning 35,000 per month. My lords. My lords,
What is your income?
45,000, my lords. I have produced the salary slips, my lords. I have started a
Your salary is 45,000. Why would the court grant 50,000?
That's the
come to the
I will. Page number 24, my lords. I could not file the assets and liabilities in time, my lords.
Why you have not filed?
My lords, my father has suffered a heart attack, my lords. I produced the order sheet also, my lords. 2 opportunities were granted. I could not file. Assets and liabilities were taken as not filed. Arguments as taken as heard, and it was posted for orders, my lords.
Criminal miscellaneous is of the
Page
year
number
2023.
Please, ma'am.
That should be 5 May, Your Lordship. On 21.
And the order is passed on 21st August 2024.
That should be 5 May.
You have come before this court when on 25/1/2025.
Please, ma'am.
There is no petition to condone the delay.
That is a writ petition.
So writ petition, whenever you want to file, you can file.
No, my lords, the problem was with, because his father was not feeling
When
well.
was that? Please tell the court when your father. Huh?
Certain dates, Your Lordship can note it. On 21/2/2024, your case expired.
21?
21/2/2024, Your Lordship. Your case expired. On 30/3/2024, I have adduced my evidence.
What is that, 30?
30/3/2024, Your Lordship. I have adduced my evidence. And since the respondent is already placed started before the trial court, the cross-examination has been taken as nil on that very same day. On 30/3/2024, ex parte order has been recalled. But what has to be noted at this point is that even prior to us filing the same petition, they are very well aware and they are also prosecuting a a petition for divorce. So they are well aware that there are certain disputes between the petitioner and respondent. So the reason which they are saying that this has been passed in ex parte, even assuming that it has been passed in ex parte, they have anyways recalled the order also. On 30/3/2024, they have recalled the ex parte order. They were given an opportunity to file the assets and liabilities on 25/4/2024.
What is that?
4/2024.
24?
25/4/2024, they were given an opportunity to file their assets and liabilities affidavit. They have failed to do so. Until 11/7/2024, they have failed to do so. On 11/7/2024, between those 2 dates, there have been numerous, almost 2 to 3 dates, which is evident from the order sheet. On
They didn't file.
On 25/4/2024, they were
11/7/2024.
the assets and liabilities has been taken as not filed. They are also not present on that particular day. We have addressed our arguments with respect to the interim maintenance, and it has been posted for orders. And then orders has been passed on 21/8/2024. So this is the factual circumstance. These are the dates. And what contention they are saying that they have not filed the assets and liabilities affidavit, it is evident from the order sheet. And if your lordships can kindly turn to page number 22 of the petition, internal page 7 of the interim or the impugned order, your lordship. Para 11, your lordship. In this case, the marriage between the petition number 1 and respondent is admitted fact.
3 years old child Advait PA was born due to wedlock is admitted fact. Further, it is admitted fact that petition number 1 is working as assistant professor and drawing monthly salary of rupees 35,000. Further, in the objections, the objections which the respondent has filed, Your Lordship, at para number 15, categorically admitted that he is BE MTech PhD holder and is working as CEO in MS Biopal Biosciences Private Limited, Bengaluru. Lordship, he is the founder of the company. He is the CEO of that company. He is earning an handsome salary of minimum 6 lakhs per month, Your Lordship. This, to prove this or to dispute it, they were supposed to file the assets and liabilities before the trial court, which they have failed to do so. Your Lordship. It is our understanding, and it is.
I'll not interfere with this order.
My lords, may I bring the my lord's attention to our order sheet, my lords. Let's kindly take page number 79. 78, 33/2025 was directed to file assets and liabilities, my lords. 25/4 PO was on training, my lords. Matter got adjourned to 8/7, my lords. That day matter was not taken up.
Why in the lower court it will be only given to the judge? They won't file in the registry.
My lords, the bona fide reason.
The provision to file before the registry is not there in the courts before Karnataka. You'll have to file it in the open court itself.
On 8/7, 11/7, it is taken as not filed. After that, later, my lords, I filed my assets and liabilities. Now the assets and liabilities are on record before the family court, my lords. Sir, none case, none argument, Martin Bidi. My lords, page number 90, my lords, have produced the
How can your
discharge.
salary be 35,000? You are a CEO of a company.
My lords, it's a startup company, my lords. It is a startup. My lords, should I not play?
What is your age?
35. 36.
What were you doing before this?
I was working in some company is what I was instructed. My lords, I'm not sure.
So in fact, on the previous day, Your Lordship had
My lords,
observed
I
that
will
not
bring
filed the
only.
assets.
My lords,
See what he's saying. You saying previous day something happened.
Please.
In fact, on the previous day, Your Lordship had categorically asked them as to why they have not filed the assets and liabilities, and Your Lordship had posted the matter today under the caption of judgment to pass the judgment, Your Lordship.
That day, my colleague asked for time, my lords. He asked for time.
Place your statement of assets and liabilities before this court. We'll see what it is.
My lords, may I bring my lord's attention to the reasoning?
Not all those things. Give place your statement.
It is already on
They have
record. I
filed
placed
Your
it, my lords.
They have filed it.
It
Page
is there.
82.
Page number 82. Page number 82 is assets and liabilities that I have filed it before.
Where are your bank accounts? What is the amount in the bank?
IT returns also produced, my lords. The entire thing is
No.
my
Where
lords.
are your
From
bank accounts?
Bank accounts. From page number 113, my lords.
Page number?
113.
139.
My lords, 112 is the salary slip, my lords.
Anyhow, that's your, you can have any slip. So let's see your bank account. Where is the salary credited to your account?
Page number 120, my lords. 1st October.
Where is the company's account?
122.
It's a startup company.
Yeah, it is from Biopol only, my lords. Page number 122.
Where is the company's account?
Company's account. My lords.
Company will be having an account, bank account.
In page number 122, it is shown as it is transferred from.
How many
Biopol
partners
finance.
are there in the company?
My lords, I am not aware.
Find out.
Please,
And let that company account also be placed before the court.
I'll do it.
The petitioner is a CEO of
Biopol Biotech.
Biopol Biotech Limited. Biopol Biotech.
Biopol Biosciences Private Limited.
Biopol Biosciences Private Limited. By the next date of hearing, the petitioner shall place before the court the bank statement of the company.
Please. Well, it's the interim order was, the arrangement was made by this honorable court to deposit 10,000 to open a bank account in the name of the child and to deposit 10,000, which I have been doing well. So I complied with the order.
Why should it be a bank account? That I'm not able to understand.
So like that is the orders of this honorable
Why
court.
not? Then who will take care of the?
My lord, she is residing with me, my lords. I am taking care of her. I am taking care of the child, my lords.
That's what they are residing in the
Don't
same
have to be
house.
so excited.
No, my lords, their case.
Just wait, please.
That is not in dispute. They are residing
What
in the
is-
same house. That
then
is-
why- what is
that
this,
also mentioned in our.
My lords,
What has happened is. What has
When
happened
both
is-
of you are residing together, what is
Not
this?
together, Your Lordship. In the same residential
what is this,
premises,
my lords?
But in a different portion of the premises, Your Lordship. What has happened is they may be in the same.
What is,
house.
no, that rent is paid by whom?
So rent is being paid by them because there's no concept of rent, Your Lordship. There's no need for rent.
So how much is the
Lordship,
rent?
But what has happened is, if I may.
How much
produce
is the rent?
It's a.
this, I believe it's their own. Rental is 25.
My lords,
But
the
rent.
honorable trial court, my lords, passed order only on the ground that she has to live in a rented house and she has to pay. Let's kindly see page number 25, my lords.
And you don't, you can argue like you can be composed, don't worry.
No.
Court is not running away, still time is there.
I'm sorry.
Yes.
That
And
is
so, both of them are residing in the same house, in the very same house. Husband is taking care of the rent. Wife is getting 35,000.
If I may, Your Lordship. Husband is not taking care of the rent.
Who is paying, sir?
Husband is not taking.
Just wait, you can't question him like that. Yes.
She is also contributing for that.
What is that she's contributing? Where did you say?
She is contributing. How much?
My lords, I am informed that it's their own house. I am informed that it is their own house. It's standing in father's name.
Please, Your Lordship. Lordship, it is an own house.
It's their own
The
house.
concept of rent.
It is their own house. Wife is earning 35,000 per month.
Please, Your Lordship.
What is the age of the child?
Age of the child is 4 years, but what needs
Please
to be
wait.
considered?
What are they? No, wife do not require any other amount because there is no, she has a house to live in.
No, Lordship. The Lordships can kindly turn to page number 39 of the petition, which is our assets and liabilities which we have filed before the trial court. The child has been diagnosed with genetic issue, Your Lordship, detected and need of more diagnosis of thalassemia. So what? This is a genetic disorder, and for medication itself, and we have also sought for that itself, Your Lordship, in the assets and
My lords,
liabilities.
I will
Except for
undertake, my
medical
lords, that I'll
expense-
take care of
Let
expenses.
him
Such
come
a
up with
medical
same
expenses
order.
itself.
So and so company, the bank statement of the said company shall be placed before this court. When did the company start? So he started.
I will place an affidavit on
They may be also
the.
directed to produce the constitution deed because they are only a shareholders of.
I will place it, my lords.
Whatever they are producing or whatever they are showing in the form of assets and liabilities is only with respect to the petitioner. It is my understanding and is my instructions that 70% of the constitution of the firm is in the name of the mother of the petitioner. So they may be they may be directed to also file the constitution deed also. Because in case if 70% of the shares is in the name of the mother and the father, they are saying.
First of all, if you look at the bank statement, what are the transactions you will know?
That is his personal bank statement.
I said you didn't hear, I think, the order. I said the company's account. Yes. Yes. List the matter when?
1 week, my lords.
List the matter on 29th.
It's interim order may kindly be.
Interim order earlier granted is extended till then.
Great.
Number 91, finally.
And if I may, Your Lordship, the modification of interim order, the amount is being credited on one account.
Is the amount that is deposited by the petitioner shall be, that amount shall be given to the respondent and shall continue to pay to the respondent.
They have already deposited 60,000.
That's what I'm saying, that she will be given to the mother and continue to pay to the mother. Yes. It is submitted that the boy is suffering with the thalassemia, the genetic disease. Yes. Next.
Cell number 91, final hearing. Samarth Prakash.
Give that file.
For the petitioner's matter, my lords, the main matter has been disposed of.
When is it?
Our main matter was disposed of last year on 38/24. Just
30?
17/8/24.
17/8/24. When counsel for the petitioner submits that the main MC itself is disposed of on 17/8/2024. Hence, nothing survives for consideration of this petition. Accordingly dismissed as infractious. And 92.
92. Indian Haji.
Lord, last time your lordship had to come for the final hearing. Since last 6 to 7 dates, every time either they don't appear or they come and ask for time. So even
Let me look at it.
Yes.
Let me look at this.
from last December, your lordship.
Interim order if is suspended until further orders.
Until
Both
date, they have
parties
not
are
filed
ready.
assets and
They're also on the
liabilities.
beginning matter. Let's just matter after 2 weeks.
Much obliged.
Petitioner, respondent or present. File certain documents. The release. He asked time first time on 10/3/2025. 12/2/2025 there is no representation. At the 1/2/25 request of respondent.
And without informing myself or any of my colleagues,
Yes, Mr.
they always
Counsel.
take time.
Mr. Counsel.
Yes, my lord.
Yes.
My lord, kindly have it on next week, my lord. My senior will appear and address
Why?
the argument, my lord.
This is
Some
matter.
inconvenience we
But
have.
till date, the senior has not appeared last 6 to 7 times, my lord.
Listen, please listen. This is matter on Tuesday, on the day, whether no further time will be granted, and finally,
Lord, an humble submission, if it can be kept on Wednesday, I have 2 RSA matters on Monday and Tuesday.
Wednesday.
Much up. Lord, if a cost can be put, just an humble request, my lord, because in 6 to 7 times.
Next.
Much up.
Hmm? 30.
ಅಷ್ಟೇನಾ?